Good evening. This is the October 6th meeting of the Civilian Police Oversight Agency Board. And I'd like to welcome you to this meeting. We have a quorum present with members Eric Olivas, Vice Chair, Tara Mia Pruitt, Chantel Galloway, and Eric Nixon present. So in keeping with the Governor's declaration of a public health emergency and a ban on large public gatherings, this meeting will be on Zoom, and there's instructions that were attached to the agenda for how you can access this meeting on GovTV or get the recording of the meeting after it's over. So we will general public comments were taken until 4 o'clock this afternoon, and they will be submitted, or they have been submitted to the members of the board. So with that, I'd like to go to the mission statement, item 2, which is advancing constitutional policing and accountability for APD and the Albuquerque community. Oh, before I forget, let me go back a little bit. Besides members of the board who are present, we have Edward Harness, who's the executive director of the CPOA. I believe Katrina Segala is on, yes. And we also I see now that we have our 6th member, President Doug Mitchell. So we have 6 of the 7 current members of the POB. Okay, so back to other people who are present. There's from the CPOA, Valerie Brella and Katrina Segala, and our counsel, Tina Gooch. From APD, I see Commander Rivera, and from the city, I see Lindsay Van Meter, and I believe that's everyone who I can identify at the present. So if anyone else like to be identified, please make yourself known. So back to the agenda. We're at item 3, approval of the agenda. The agenda was circulated prior to the meeting. So I'd like a motion to approve the agenda.
I'd like to make a motion to approve the agenda as drafted.
Okay.
Second.
All right. So the motion's been made and seconded. So we'll do everything by roll call vote in these days. So Member Armijo Pruitt.
Yes.
Member Galloway.
Yes.
Member Mitchell.
Yes.
Member Nixon.
Yes.
Member Olivas.
Yes.
And the chair votes yes. So the motion's approved. The agenda is approved 6-0. We will, we may have some changes since Chief Medina is early on the agenda, and he's informed us that he may be late because he's in a meeting with the mayor. So when his time comes up, if he's not here, we will we'll hold that until he gets here. So that's within our bylaws how we can do that. So public comments, we've received one public comment from Geraldine Amato, and that has been circulated to the board, and the board will review that. Board members individually will review that. So that was item 4. Item 5, review and approval of the minutes. So the minutes have been sent to the board, and I would entertain a motion for approval of the minutes.
So moved.
Second.
All right, roll call. Member Armijo Pruitt.
Yes.
Member Galloway.
Yes.
Member Mitchell.
Yes.
Member Nixon.
Yes.
Member Olivas.
Yes.
Chair votes yes. So the minutes are approved as presented unanimously. So we are at APD, and we're at the item 6, which is reports from the city. And the first report is from Interim Chief Harold Medina, but we will wait until he's available. So moving right to the second report, the crash review quarterly update, whose I believe is going to be given by Commander Rivera, who's been waiting patiently to do this to the point where I think it's become a lengthier, or it covers a longer time span than it originally had. So Commander Rivera, it's yours. The floor is yours.
Can you hear me, Mr. Chair? Chairman Cass? Can you hear me?
Yes.
Okay, thank you. It's Commander Rivera for APD. Thanks for the board's time today. I sent this via email. Did you guys get the handout or the PowerPoint? You have it? Okay.
Yes, sir, we did.
Okay, so Chairman Castle presenting APD personnel involved in crashes for the fourth quarter, so April 1st this year to June 30th. So we typically have crash review board once per month, and so from April to June of this year, the board did have crash review every month from April to June. Our final numbers for the fourth quarter were there were 25 non-preventable crashes by APD personnel, 37 preventable crashes by APD personnel. One was ruled a non-crash, and non-crash could be such thing as, let's say, deliberate act, pursuit or something where an officer rams a vehicle or something. There's a couple other scenarios, but there was one non-crash for this quarter. 6 officers had 2 or more preventable crashes within a 12-month period. And just a disclaimer, the officer's chain of command or the department personnel's chain of command imposes discipline, not the crash review board. We just make recommendations. The payout claims came from risk management for third-party payouts for the same quarter, April 1st, 2020 to June. It should say June 30th, 2020. I think it says June 20th on the handout. Apologize. Third-party payouts totaled $176,833.58. There's a total of 29 claims. First-party payouts for the same fourth quarter, $201,464.36, and there was 38 claims. And again, these payout claims can come from crashes from last year, 2 years ago, 6 months ago, not necessarily this quarter. But I'm available to take any questions now from the board.
Yeah, I have a question. Commander, how does this compare historically? Are we getting better?
Without looking at the data, I'd say it's probably pretty status closer. It comes and goes. Traffic has been lighter due to COVID, but we are actually picking up in numbers in the way of personnel. So it could technically kind of be a wash with less traffic on the roadway, but more officers on the street. So without looking at the data, it seems to be about status quo.
Okay, thank you.
Sure. Any other questions?
Yes, I have a question. Could you just briefly detail what kinds of interventions and actions the department is taking to try to address some of those that are ruled as preventable crashes?
Yeah, that's where it gets a little, I'm kind of out of the loop because we just make our recommendations to internal affairs, and then internal affairs then forwards the, let's say, the preventable to that officer or civilian's chain of command, and then from there. But the first preventable is a class 6 sanction, so an automatic written reprimand for those officers. Like we have right here 6 officers had 2 or more preventable crashes with the last 12 months. That chain of command, I mean, it varies from an automatic 8 hours off to going out to, and that's the thing now with COVID though, the Fegan driving school has been on hold. So there's an added twist there where typically a chain of command can have his officer through the academy do additional training at the driving track. But since COVID's in effect, that's on hold. So that is kind of a, kind of stinks because I think it's a good course, but right now we just have to deal with what we have. But yeah, so like I said, sends out the recommended discipline to the chain of command, and then their chain of command of that particular personnel is the one that imposes whatever they wish. Like I said, it's usually it's pretty standard. If it's your first crash, it's automatic written reprimand. If it's your second crash, it's pretty much already automatic 8-hour suspension. And so it's but like I said, there's other avenues that we could go, but with COVID, we're kind of stuck with just going out discipline.
Thank you. I appreciate that.
Sure. Any other questions?
So I'm looking, are there any other questions? So if not, I would like to thank Commander Rivera for his presentation, and also acknowledge that you're free to leave if you're so inclined. So that's one of the things I forget to do. So thank you again. And at this point, I'd like to also acknowledge that we have received the Professional Standards Division Internal Affairs report for September, as well as the Force Division Internal Affairs statistical data report for September. So both of those reports from Internal Affairs have been submitted. And I'd just like to point out, if you haven't looked at the Force Division report, one of the things I find interesting about it is that it gives the use of force events in terms of the number of events per 1,000 calls or 1,000 CADs. And it runs right around, 1.5, to 2 uses of force per 1,000 calls. And it's just something I found interesting, but I'm not sure whether there's a trend involved yet, or have to look at some of these. But I just like, again, to acknowledge that we've received those reports. So we'll continue to move on through the APD or through the city reports.
Dr.
And,
Ken,
yes.
with regards to this, and I just kind of want to throw up a marker here real quickly, maybe for the staff to follow up on, or the director. But I wonder if we, as you say there, that we'd have to look further at the data to determine if there's a trend there. And we certainly have our own very talented data analysts at the agency. And I guess I'm wondering if that's something that they're keeping track of, and if not, if that's something that we can start looking at. So just kind of a little marker there for folks to be aware of, and hopefully for our staff to work on as well.
Thank you. So I've just been informed that Chief Medina will be unable to join us this evening, and he sends his regrets. So moving on, report from City Council. And who's here to report from City Council? I believe that Mr. Sylvan. Yes, thank you. Go ahead.
Can you hear me okay, right?
You're good.
Okay, cool. Not much to report tonight. The only thing that we're reporting out is that interviews have started for with the counselors this week with one of the applicants for the board. And then next week, an interview will start with another applicant for the board. This council is kind of jammed up right now because it's budget season, and they're trying to squeeze in what should have taken place in May and June to right now. And, Thursday is the markup. Next Thursday is the markup. This Thursday is social goals for the budget. And I know that Director Harness will probably want to talk about his part of the budget that was heard last Thursday, and it went really well with the council, and there were no questions asked. With that, Chair Cass, I stand for questions.
Any questions from the board?
On the board vacancies, do you are you all proactive in terms of trying to get people ready to go, anticipating vacancies? It seems like I was told that the board hasn't had a full board in about 3 years, 2 to 3 years or something. At least that was represented. And that seems pretty exorbitant in terms of the amount of vacancies that we've had and how long it takes to get on the board. And so I'm just wondering, you know, some places establish eligibility lists and things like that so that they have somebody through the process and ready to go when a vacancy should occur. So is that something that you all would be inclined to entertain?
Chair Cass, Board Member Mitchell, before I got involved with the board, I understand that the Director of City Council resigned and retired, and that's kind of where the hiccup occurred, that there's been vacancies. And right now, the Director of Council, Stephanie Yara, is making sure that we're getting back on track. And to answer your question, yes, we are trying to rapidly go through and make sure we're vetting people properly with the committee and having people ready, because, you know, it's a CASA requirement to, you know, have a fully staffed oversight board. And, you know, the council director is aware of this, and the others on the committee are also aware of this, and so are the counselors. It takes a lot of, how do you say this? With 9 different counselors and multiple applicants to the board, the process does take a while because you have to schedule around counselors' schedules and have to get everything just lined up. So, you know, moving forward with the 2 applicants that we have in the hopper right now, I think we should be pretty close to having them hopefully heard at the council meeting by the end of the month, if not early November.
Okay, thank you.
Any other questions for Mr. Sylvan? All right, well, thank you. I appreciate your report, and we'll move on to the mayor's office.
Good evening, Chair Dr. Cass and members of the board. This is Lindsay Van Meter from City Legal. I'll be speaking to you on behalf of the mayor's office as well as City Legal. So to begin with the report from the mayor's office, yesterday the mayor announced that the city has launched a nationwide search for the next chief of police for Albuquerque Police Department. The search is expected to take place over the next several months, and we'll put an emphasis on community input and the police reform process, which has made major steps forward under this administration. The top priority will remain fighting violent crime, while continuing the big drops in nonviolent crime that the city has seen over the last 3 years. The mayor is going to take the time that it needs to find, the city needs to find the right chief. And the goal will be to accept input from as many residents as possible. The administration is also bringing a specialist on board to ensure that the national search is done well, and that will serve as the point of contact for potential applicants. And the city is forming a search committee and community leaders who will consolidate input and vet candidates. The city will announce a schedule for community input sessions in the coming weeks, where it will request that residents, advocates, organizations, and businesses voice their opinions. I will put in the chat, it'll take me a minute, but I'll put in the chat the community input email address, and also where the job posting can be found. So that is the update from the mayor's office. Are there any questions?
Do you know who's going to be on the selection committee yet? And will the civilian oversight committee be represented?
I don't know the answer to that yet. It's pretty early in this process.
Well, if you can take the message back, I think we should be represented.
I will, and you can also send an email to that email address that I'll put in the chat, but I will take the message back.
Okay, thank you.
Member Galloway?
Thanks, Lindsay. Just for the agency, I don't know, when links like this are submitted to the chat box, is there a place that anybody who's watching may be able to access these links?
I think that's more of a question for
The agency, yeah.
yeah, whoever's running your Zoom meeting.
Chair Cass, Member Galloway, yes, the chat along with the video are saved and they are part of the record.
Okay, thank you.
Okay. If there aren't any other questions based on the administration's report, the report from legal is that we did have a status conference today before Judge Browning. Unfortunately, there were some technical difficulties with the court's systems, and members of the public who wanted to listen in to the hearing, the report that we've received is generally they were not able to hear the broadcast through their system. So Judge Browning did pass along his regrets to the community members. He had been under the impression that there weren't going to be any technical issues, and he will work to make sure that there will not be technical issues for what we hope will be the public hearing scheduled in late November or early December. The city and the DOJ are going to work with the court to make sure that a better system is used to allow participation from the community, or at least access to the hearing from the community. In addition, the monitor's 12th report is expected to be published on November 11th. And that is all I have for you. Do you have any questions? Thank you.
And thank you. I appreciate it. And if you want to leave, you're free to go. So
Thank you very
Thank you.
much.
So moving right along, reports from CPCs.
Good evening, Chair Dr. Cass, Honorable Board, the report for the CPCs. They plan to have a CPC summit, a meeting of all the CPCs on the 24th, October 24th at 10 a.m. Most likely that will be done through a Zoom webinar process. And those invites will be going out to all the board members as well as other members of the community and all of the CPCs. The position funding for the CPCs remained through the committee of the whole process. So we will be adding a liaison and an office admin to facilitate the CPCs under the umbrella of the CPOA. The CPC ordinance goes into effect tomorrow. It was signed and it's been published, and 5 days after signed publication will be tomorrow. So the CPC ordinance goes into effect tomorrow. The CPC liaison interviews will be conducted on Friday. There will be a panel of interviewees anyway, there's going to be a panel of people conducting the interview. Myself, Amanda, Deputy Chief Garcia, Ron Hopkowitz from the Southeast, Vicki Williams from the Northeast, Eric Jackson from the Northwest. We will be the interview panel for the CPC liaison position. And this morning I received the batch of, or the batches, I should say, of qualified applicants from HR for the office assistant position for the CPCs. It's going to take a while to go through those. There were initially 112 applicants, and I believe each batch that I received probably had 7 to 9 applicants. So there's probably roughly 45 applicants to go through to decide who's going to be getting interviewed for the office assistant position. Most likely, it would be good to have the liaison in place before we fill that position, but we'll see how that goes. So other than that, I stand for questions regarding the CPCs.
Are there any questions regarding CPCs? So I only see half of the people at one time. So if you raise your hand, I'll try to find you. But if you raise your real hand, if you raise your virtual hand, it may work too. So one or the other. So thank you. So if moving on to report from APOA, is there anyone from APOA who wishes to report? Seeing no representative from APOA, we'll move to the Public Safety Committee report. Is that you, Mr. Sylvan?
Chair Cass, wasn't prepared to give a Public Safety Committee report, but I can prepare that next time.
Chair Dr. Cass, I can also add that the upcoming Public Safety Committee meeting has been canceled, the one on the 13th of October.
When was the most recent Public Safety Committee meeting?
Chair Cass, I believe it was, and Director Harness, correct me if I'm wrong. I think it was 2 weeks ago. It's been a while. Public Safety Committees meetings don't happen that often.
Okay, thank you. All right, well, thank you then. If there's no more for Public Safety Committee, CPOA, Director Harness, please.
Chair Dr. Cass, Honorable Board, good evening once again. As Ms. Van Meter pointed out, there were technical problems with the status conference this morning for the stakeholders and the public. So myself and Ms. Gooch were unable to attend. You saw, or you should have seen, the flurry of emails that were coming from the Department of Justice regarding what was going on. As soon as the transcript is done, we will make sure that it is forwarded to board members for your purview. The third quarter City Council report is due on the 19th of October, so I'll be submitting that. The Committee of the Whole was last Tuesday, and our funding increases remained and are moving forward. So we will be authorized 14 general fund positions. And as outlined in our position papers, that would mean 6 investigators, a data analyst, a policy analyst, a senior admin, an admin, a community engagement specialist, a CPC liaison, an administrative assistant or an office assistant for the CPC liaison, and executive director. As far as the budget timeline goes, the last update that I've received is that final action on the budget will be on the 19th of October. And then that's from the City Council. And then the mayor will hold a press conference and sign the new budget into effect on October 29th. I'll be addressing the APD lateral class on the 29th of October. We at the CPOA have been working with the new system designer for Benchmark, which is going to be the new case management software, to integrate the complaint process into Benchmark which will be replacing IA Pro. We've having those design sessions every couple of weeks. Dr. Cass sat in on one of those a couple of weeks ago. We've gotten to the point where we have the entire complaint process mapped out within the system, and we have about 3/4 of the forms formulated for that system. The next step will be integrating the mediation portion into the system. I don't know exactly when this will be rolling out, but we continue to work on that every couple of weeks. As of Monday, the 28th, we are back to fully staffed with hiring Antonio Coca as our last vacancy filled for investigator at this point. And then the last issue is NACOL. The live webinars concluded on the 22nd of September. The recorded webinars will be available until the 31st of December. Now, if you recall, in reviewing IMRs 10 and 11, the monitor needs some sort of testing for attendance at NACOL for the investigators and for the board. So I'm hoping by Friday, everyone who registered for the conference who is a board member or an investigator will be receiving an email from me with directions on how to fill out a narrative for your attendance at these NACOL seminars, and how you will bring those principles and applications for what you attended and what you learned to the CPOA. My expectation is that you would have those to me by the end of November. So you have about 7 weeks to complete that and get it to me for compliance for IMR 13. And other than that, I stand for questions.
Director Harness, could you give us a quick update on the motion that the board passed at our last meeting with regards to making materials available to the board for case review, just as far as a timeline or kind of technical steps that you or the agency may be taking, or challenges you may be encountering?
Member Dr. Cass, Member Olivas, yes, and I believe that those have been drafted and put into your policies for final adoption this evening.
Okay, so as far as I'm just saying, as far as the mechanics at the agency, do you have an idea when those may be implemented if the board does choose to adopt those final changes? Do you think that that'll be available for the November meeting or December next year? What's your timeline?
Well, member Dr. Cass, Member Olivas, we already have in place the ability to download cases and make them available through a link. As I described in the last meeting, it's a very time-consuming process. So we will see, based upon the caseload and the number of cases, we will see if that is a practicality. And I will, if it's not, I will bring it to the board's attention at the next meeting. The problem is with cases that involve video, It is a very time-consuming process for those to be downloaded into the storage site where they're made available online. Currently, that's the process that we use for the case review committee for their audit process. Doing that for absolutely every case is going to be very time-consuming.
Thank you, and I guess I would just say, just keep us updated and see if we can work together if there's challenges to try to work to a solution that benefits everybody and helps lighten that load if it's possible. So just keep us in the loop. Thank you.
Any other questions for Director Harness? If not, we'll.
Yes, I do.
Oh, all right, go ahead.
Thank you. So you mentioned that there was some kind of a narrative that we had to write because it was required that we attend NACOL. Is that correct?
Member Dr. Cass, Member Armijo Pruitt. The requirements from the monitor wanting a testing mechanism for those that attend NACOL as a part of their ongoing training.
Is that NACOL specific, or is that like there's a requirement for some sort of training and this is for us what's gonna fill that requirement right now?
Member Dr. Cass, Member Armijo Pruitt, it is not NACOL specific. That's just what you have in front of you at this point. There are other trainings that have a testing component built into them that the investigators have attended, which the monitor finds acceptable. But it is hard to find those training components, those trainings that have testing components attached to them. And so the monitor wants any sort of testing, any sort of training to have a testing component attached to it for satisfaction for the monitoring report.
Okay, thank you.
Other questions? I'm scanning the room. So seeing no further questions, we'll move on to item 7, which is hearing on requests for reconsiderations, and we have no requests for reconsiderations today. So we will move on to item 8, which is case review and administratively closed cases. So I would accept a motion to either, we can do these one by one or we can do the group, and I'm if there, let's I would entertain a motion to accept the cases that are listed in the agenda. I can read them. 09720, 108-20, 160-20, 175-20, 180-20, 185-20, and 200-20. So I'd entertain a motion to accept those cases as presented in the findings.
So moved, but I have a question when we get to that point.
Second?
Second.
All right, so now we can discuss those cases. So if there's discussion, the floor is open. So Member Mitchell.
Director Harness, I don't recall the case number, but I was really concerned about that one case where the mental health professionals had made that referral, and somehow that seemed like that got tangled up in a bureaucratic morass, and the police didn't get dispatched, and the professionals were thinking it was a potential suicide, and I'm not even sure it was in this group of cases, but I'm just wondering if it is in this group of cases, has there been any follow-up with APD? I know the lieutenant had kind of indicated some urgency around that, and I would echo that. It seems like that is an area where if it requires policy development, that should jump up to the top of the list pretty fast. when someone's life is at risk.
Chair Dr. Cass, Member Mitchell, I believe that case was 10820 maybe.
18520.
Thank you, 18520. The concerns for that case, I passed on directly to Lieutenant Dietzel at the Crisis Intervention Unit, and he acknowledged that it is there's a problem, there's a hole in the policy. So they are aware of it. 219 was before this board for comment on the 14th of July. But I don't know that this issue was resolved by the latest review and change in 2-19.
It might be advisable to put that on the agenda for the next meeting and invite the lieutenant to come present what they're doing to get that resolved quickly. I'm just afraid it's going to get lost in the bureaucratic maze and, you know, not get dealt with in a timely fashion. I'm not saying that they're not dealing with it, but it seems like that should be a pretty high priority for APD to get that straightened out. Thank you.
So I'm sorry, were you making a motion to have that put on the agenda or have that reviewed?
I can.
We can, well, I don't think this is the time
Right.
for motions, but we can certainly put this on the agenda without a motion.
Well, I agree with him. I think that's.
Yeah, I don't think this requires a motion. I think we can, you know, it can be put on the agenda without a motion. So, I mean, the idea is that we should invite the Lieutenant Dietzel to report on the status of that policy. And he's probably the policy owner, I believe. Is that right? You know, if that's the case.
Dr. Cass, yes, that would be Lieutenant Dietzel. He is the policy owner. Yes.
Right. So, I mean, that's okay. Member Galloway, you have your hand up?
Thank you, Dr. Cass. Yeah, Doug, I appreciate that because I had the same concern, but my question to Director Harness was, has this been something that the Policy and Procedure Committee could maybe partner with the CIT to push it along? Because it's been in commentary or review by the APOA, DOJ, and independent monitors since April of 2019. So I didn't know if Dr. Cass had any ideas as to why or where that stands, if that's anything that the policy committee has in front of them. And then maybe just the call out to the owner of the policy to see if we can assist first.
Chair Dr. Cass, Member Galloway, 219 was that Policy and Procedures Review Board in mid-July, and it was sent to the CPOA board on the 14th of July of this year. So it's probably at the monitor at this point for its last review from PPRB in July.
I'm sorry, I may have misunderstood, but I thought from the letter that the owner of the policy had stated there hadn't really been any movement on it, though.
Well, Chair Dr. Cass, Member Galloway, I'm going off of the record for what's been submitted to the CPOA board.
But we don't know if that had any additional changes or anything since it went to the monitor and DOJ and.
Chair Dr. Cass, Member Galloway, no, I don't know if there's any changes past the board's 30-day commentary period.
Okay, yeah, that was my question, was if there was anything new that had happened, because my understanding from the letter drafted by the agency, there wasn't. Anyway, just the same level of can we help push that along? And if Dr. Cass knew anything more.
I'm sorry, I have a question. How is the reorganization of some of the mental health professional or department within APD? How is that affected by, or how does this affect the function? I mean, I believe, I'm not sure who's moving where, but I thought that there was some part of the mental health response unit or team that was being reorganized to the public safety. I mean, does anyone have any information on that?
Chair Dr. Cass, based upon the meeting at the Committee of the Whole regarding funding for the Public Safety Department, it listed seven APD personnel being transferred from APD to that department for, I believe they were from the Crisis Intervention Unit. But I can't speak specifically regarding that and whether or not the Public Safety Department will take care of what is this intake glitch that's described by this complainant.
Member Amir Pruitt, you had your, and then one of, yeah, go ahead, Member Amir Pruitt.
So my questions weren't really around, I mean, I had the same questions about this exact same case, but I think everybody's addressed them. I had a couple other questions, not just sort of curiosities. The 9720, the case with the officer on Chief's overtime who there was a complaint that he was blocking the handicap ramp, and the response was there was no SOP violated, and that was the presentation of the car in that way was a request by the management that hired him through Walmart. And I was just wondering that is there no, it felt like a kind of blurry space where, I mean, if a management of a place that asks the officers that are doing their chief's overtime with them to do things that are counter to other laws, like, you know, I don't know what was actually happening there with the handicap ramp at the Walmart on the sidewalk, I guess, and whether it was really fully blocked or not. But is that not something that would be addressed by oversight of APD, or is that something that there's another avenue for?
Chair Dr. Cass, Member Armijo Pruitt. For this case, we reached out to the complainant so that we could have specific information on which we could act, and we could have specific evidence as a statement that we could act upon. And this complainant gave us essentially false information, false phone number, no email address, no phone number, no address to follow up, and that's pointed out in the letter. And in the complaint, the complainant also does ask that we reach out to the supervisors to bring it to the supervisor's attention, and that was done in this case.
So if you had been able to contact the complainant, or if this had been done in an anonymous fashion and not with sort of fake contact information with 555-1234, would this have been, what would that process have looked like? Say that you contacted the complainant says, here's pictures, it's entirely blocked, the handicap sidewalk ramp. Then what would that look like in terms of an SOP violation? Or is there something that addresses that?
Chair Dr. Cass, Member Armijo Pruitt, then there would have been an investigation conducted into whether or not there were SOP violations based upon evidence presented.
I guess what I'm wondering is, in this circumstance, a police officer who's working for a business, and the business asks them to do something that is contrary to what, you know, other laws say is okay. What is there an SOP for that in particular that addresses when they're being employed by someone else?
Chair Dr. Cass, Member Armijo Pruitt, I think the letter addresses generally the concept of the management wanting the high profile parking of the APD vehicle. So
Right.
that's a general statement. Had we information and a complaint and a statement from the complainant on which evidence to move forward, then there would be an examination of whether or not the parking of the vehicle was in violation of laws, parking ordinances, those other things. But in this case, that's not the case here. We can't apply the general statements for a chief's overtime and management's wishes to a specific case without evidence to base an investigation.
Let's see, Member Levis, did you have your hand raised? Go ahead. Thank you.
Thank you, Chair Dr. Cass. So I had several cases that I wanted to discuss, and I think I'll jump in on these that we've recently talked about. So 185-20 with these mental health orders. I think just a couple of comments I wanted to voice, and certainly if we invite the speaker, we can address these again. But one of the things that we are informed of here is that there's not a central intake process for these orders. That just seems completely contrary to logic here. If you have providers, you should make that as easy as possible for them to get those orders to the department, and then have the department with a centralized staff assign those orders to individuals, hopefully that are CIT trained or otherwise well equipped to deal with these crises, rather than sending this to the area command via fax and asking each area command to deal with this. So that just seems like a pretty common sense solution here. And I'd like to hear why that wouldn't work. I don't expect our staff here to be able to do that. And then just in general, since how common are these orders, so that, you know, can we get a sense of sort of how frequently this could be occurring? With regards to the case that Member Armijo Pruitt was discussing, I also have concerns about this. It's not really, I think the director was getting a little bogged down into the details of this case. I understand that we don't have details on this for obvious reasons, just that the complaint was really not able to be followed up on. But I think what she was getting at, and what I'm quite interested in as well, is a couple of questions. So the ADA doesn't apply to officers. Is that kind of what the stance of the department is? That in ADA, I'm referring to the Americans with Disabilities Act. I can understand that may not apply during perhaps a critical incident or a chase or something like that, right? We're not going to expect officers to stay out of handicap parking or not block handicap ramps. But I would assume that there's some sort of policy or some sort of training expectation of all officers, not just officers in these auxiliary commercial roles, as chief's overtime is, that they, unless there's a critical incident, they should not be violating some of these basic protections for, in this case example, individuals with disabilities. So, you know, I can imagine that there's plenty of other high-profile locations that an officer could park in that would still meet the needs of the business and not infringe on what is a right of disabled persons to have access to these public facilities. So I think that my concern here is in a general sense. And that being said, I don't necessarily expect the director to address this in regards to this case, but I would like to see the policy committee, our policy committee, if the director could help us by providing us some guidance as to what policy or policies this may apply to, or may apply to this situation, and then we could take a look at those to see, in general, if that policy needs change or better training. Again, obviously, in this instance, we may not have information. I don't think there's probably a comment from the director on either of those cases, so I'll move along to my next one. 108-20. This letter, and Director Harness, feel free to interrupt me if you do want to comment on that. This case, 108-20, the concern I had here is that the letter doesn't specifically address whether the report was filed in a timely manner. This is in regards to I believe this is a protection order or something like that, for a domestic dispute case. And so I'm just wondering, we sort of note that this is a civil matter, but I'm just kind of wondering how this applies to whether we actually looked at whether this was sent.
You're Dr. Cass, Member Olivas. This was not described as a civil matter. This was, let me make sure I have the right case here.
I'm sorry, I misspoke there.
This was the matter that was, the woman was, the complainant was concerned that she hadn't seen DV charges filed yet.
Right. And so what we had said in the letter was that it seemed like the hangup was on the end of the DA, which seems like that certainly could be the case. But I'm just wondering if we actually looked into when this report was filed, and again, sort of what does the policy say about that? How quickly are they expected to file their report or file those charges? Even though I understand the DA ultimately controls the gatekeeper of that.
Chair Dr. Cass, Member Olivas, we followed up with the field supervisor, and we followed up with the impact detective for this case, and both of them gave us statements to say that the reports were filed and that the charges were referred to the district attorney's office. So I don't know that there's an issue of timeliness that would need to be examined. The charges, the reports and the charge requests have gone to the district attorney's office.
Okay, so we did investigate whether those were filed, and they were filed in a timely manner by APD, which would be our only recourse in this situation. Thank you. I have two more cases here I wanted to look at. Let me first go to 076-20. This is a case where the complaint basically centers around this, or at least my issue in this case centers around an ID being taken from an individual who was experiencing homelessness. It was taken in a what seemed as a lawful interaction with the individual. He was asked to leave the premises because he'd been called by management to deal with trespassers, loiterers. The individual handed the officer the ID, and then the officer, sounds like, made an honest mistake here and retained that ID after arresting the individual and booking them at the prisoner transport center. So I guess the issue here, again, what I'm trying to get at too is, as we look at these, is trying to keep my mind more on policy. What can we do to prevent this from happening in a global sense? This is concerning to me because I know that from my own experiences and everything we know about homelessness, not having identification is an incredibly difficult challenge and exacerbates this cycle of homelessness. You don't have ID, you can't get access to services. You don't have ID, you can't get a job. You can't get all kinds of things that are critical to breaking that cycle. So what I'm concerned about here is the
social studies room. So.
Hey, can you please? So the question here would be,
Okay.
What does the policy say about this, and maybe how could we improve this policy so that that doesn't ever get separated from that person? Because it seems like had that been taken directly to the prisoner transport center or something like that, where it could be reunited with that individual or with that individual's belongings, there wouldn't become this chain of well, they have to go to evidence, but evidence doesn't have any information for them because they're homeless. It just seems like it creates kind of a void here where I realize it's a hard issue to sort of pinpoint where the gap was, but it seems like an important issue for us to try to address through policy. I don't know if you have any comments on that.
Chair Dr. Cass, Member Olivas, the policy for getting property to individuals that are detained at MDC would be an MDC policy. So according to the APD policy, the officer did what he was required to do in this case. And it was verified that the ID was tagged into evidence for the individual. So the inventory and belongings at the detention facility would be under their policy.
I understand. I'm just trying to think of a way that those two policies can link, because like I said, it sounds like everything was done by the book here. An honest mistake happened, but sort of, my thinking on this is that the quick fix to this is to actually get that ID to MDC so that those belongings are never separated, and you don't create this additional hurdle to this individual to have to track this identification down with very little information attached to it, because they don't have an address, they don't have a phone number, those kinds of things that help. So I'm just kind of looking for ways that we can help these institutions work together. I understand that they're separate entities, and we only have oversight authority to one, but I think that we can agree on the goal of getting those groups to work better together. Last case I wanted to comment on, 200-20, and I saw this come up in a couple of the other complaints, and I guess part of the issue here is just that in some cases we don't have lapel video reports or anything to really go on, so we're relying on interviews or conversations with supervisors, and this is an incident where I guess we reached out to the commander to sort of ask what was going on with these complaints. This is the one that's related to a custody dispute, and the commander basically assured us that this was taken care of, and that they were aware of this, and that they weren't aware of any misconduct. I guess I'm just trying to think of a way where that can be more independent from APD. I understand it probably can't be, but I just wanted to raise that concern that, when we...
Excuse me, member Olivas, it's been pointed out to me that this is an unfounded case. So if you could hold your comments about 07620 until we get to the unfounded cases, let's deal with these first and then come back to that. So.
Okay, I apologize. I think I've already finished my comment on that. Right. I think that's all I've got.
So is that all you have? I believe Member Galloway is next in line. So then Member Pruitt, Armio Pruitt, Member Galloway.
Okay, so I'm just going to follow suit. I'm going to start, Director Harness. You already have my comments on all of these, but for 09720, I understand that the hiccup here is that the agency didn't have contact information for the complainant to be able to verify. But aren't we required by the CASA or the ordinance, maybe both, maybe neither, to accept anonymous complaints?
Chair Dr. Cass, Member Galloway, yes, that's correct.
Okay.
And third-party complaints.
Okay, so if we have an anonymous complaint, are all of those administratively closed as well? I don't remember that being an issue, but I could be wrong. Because of a lack of ability to contact the complainant?
Chair Dr. Cass, Member Galloway, no, not all anonymous complaints are administratively closed.
Okay. So I guess if this is a regular chief's overtime experience for this officer, I think I remember that being the case. I guess if it was an anonymous complaint, wouldn't we have looked at that to see if this is actually happening, or how would we conduct that investigation? If we weren't going to administratively close it for an inability to talk to the complainant, how would that investigation be conducted if this were an anonymous complaint?
Chair Dr. Cass, Member Galloway, this was not an anonymous complaint. It was a complaint, I suppose, that somebody could have filed as anonymous. That's very clear on our complaint form that you can file anonymously. And then an investigator will try to develop information to verify what is in an anonymous complaint. This was not an anonymous complaint. It had a name attached to it. It had a phone number, which was false. So
I'm aware. I'm just saying, if it had been, for the sake of argument, if it had been an anonymous complaint, how would that investigation proceed? And I guess, couldn't that have been applied here?
Chair Dr. Cass, Member Galloway. Yes, I suppose we could have looked at the chief's log, tried to identify an officer, and then interviewed the officer and asked if in fact he was parked on the sidewalk.
Or even maybe a drive-by?
A drive-by?
Yeah, of that shift, that chief's overtime shift, if it's a regular shift.
Chair Dr. Cass, Member Galloway, these aren't consistently shift and filled by the same personnel on a regular basis. I'm not sure that a drive-by would be an efficient use of our investigators' time.
Sure, it sounded like, and it could not be the case, but it sounded like that particular officer was the officer that was at that location on a regular basis, but it could not have been. I did go back and identify 3 potential SOP violations with that case. Did you have an opportunity to look at that, and what are your thoughts on that? On those? And just for the board, sorry, it's SOP 1-1-4B2, which talks about, paraphrasing, personnel will obey all federal, local, and state laws at all times. Second one being SOP 5-3, which talks about take-home vehicles, and the pertinent piece being employees will not drive or use the vehicle so as to cause unfavorable comment or reflect discredit on the department. And SOP 3-20-2-B-10A, which says, while working a chief's overtime assignment, officers will adhere to all department rules and regulations as if they were on normal duty hours. Violations of this policy may result in disciplinary action and or loss of chief's overtime as stated in the section. So I think that there are possible policy violations. I am asking you if you would agree with those readings of those policies, that there were possible policy violations here.
Chair Dr. Cass, Member Galloway, if everything in the complaint is accurate and there's evidence to that, then there could be a policy violation. But there's, we can talk about hypotheticals for every complaint that comes in, there could be some policy violation that's attached to it. So yes, in theory, there could have been a policy violation.
Okay. I guess I would think that this one, I would say probably needs to be looked at a little bit closer, would be my request of the board and the agency. My next case, and following suit with the previous couple, 175-20, this one was the letter that didn't follow typical formatting. But shouldn't it at least contain the language about if new information is made available, the complaint can be refiled? That's pretty standard, and I don't believe it held that language.
Which case was this, please?
Number
175-20.
I'm opening the letter now.
Okay.
Unknown sheriff's deputy for an incident that took place in January. I'm not sure what there would be to reopen if it was involving the sheriff's department and not APD.
Perhaps if it was found to be APD, I don't know. It was just a thing in that letter because that's pretty standard in our language back to complainants that we have that in there. And bear with me. I opened that in the wrong tab. Nope, that's it for the administratively closed cases, I think.
Sorry, Member Armijo Pruitt.
Thank you. Just real quick about that letter in particular, because I had it in my notes as well. The complainant didn't say that happened in January. They didn't actually say when it happened, but then on the letter, it showed up saying this happened on January. I think because the person said it happened around 12:30, and then it showed up as January 23rd. I think that's what I saw when I read it, because I'm sort of, tracking dates as they show up places, and that was one that caught my attention because in my spreadsheet it says no date, and then the letter said there is. So that's something to look at. Separately, in terms of dates, I thought it was interesting that in some of these letters, it switched format from talking about we received your complaint dated this for an event dated this, and now it says we've received your complaint dated this and assigned an investigator on this date. Like the two dates that are listed are a separate set of dates than what used to be listed. And I wondered if that was a new format going forward. Are we switching that up to not highlight the long timelines?
Chair Dr. Cass, Member Armijo Pruitt, that's probably just individual investigators.
So there's no standardization that the investigators are asked to follow?
No, not as far as those paragraphs.
Okay. It would help me as a board member reading these things if, if all of those dates want to be in there, that's cool. But like having a standard approach makes it a little bit easier so that if 90% of the letters are going to say we received it on this day and for an event that happened this day, I would appreciate some standardization with the letters. But I think we've talked about that before.
Chair Dr. Cass, Member Armijo Pruitt, within the software that we're developing with Benchmark, it will be generating a standardized form letter to go out to the complainants.
Fantastic. I would love to see what that looks like, what the information is that you guys are going to code into that.
Any other comments by members on these administratively closed complaints and letters? I just would like to point out that I think we've identified several policies that we can take a look at, and I would encourage the board members to, choose one of those, especially the policy committee members, and look it up and bring it to the policy committee next meeting. I think that's one of the purposes of one of the things that we can get from citizen complaints is identify the policies that we think need work and then work on them. So I would suggest that we deal with look at policy 219. We can also invite Lieutenant Dietzel to our next policy or to an upcoming policy and procedures subcommittee meeting and ask him to take us through that policy and some of the issues associated with it. SOP 273, I believe, is another policy which was in this identified in the ID loss of ID policy. I think that's another one that's important. And then I would point out that chief's overtime, if you look at the documents associated with that at APD, it's primarily done by special order. And special orders have kind of confused the policy issue because they're much more dependent upon the chief or someone high in the hierarchy of APD to create special orders, and they don't see the same sort of review and scrutiny that regular policies do. And I think chief's overtime is one of those situations that I believe needs to be looked at. I think it's a controversial subject. It's certainly one that's been abused in the past, and I, from the standpoint of officers abusing it, as well as the public suffering from situations where businesses have hired, employed APD personnel, and there's more problems, more uses of force associated with those kinds of actions or with that kind of activity for APD. So I think it's certainly worth looking at. The question will be, how do we get our arms around chief's overtime as a policy, given that it's primarily special orders? But I think that's another thing that the policy committee can address. So with that, I'd like to give one last chance to anyone who has comments about these policies. And then I think we need to decide how we want to go through these 8 policies or whatever, 1, 2, 3, that are administratively closed, whether we are willing to accept these as presented, or whether there's some, what it is that the board desires to do. So we have a motion on the floor to accept these policies or accept these findings letters, and I would, and a second. We have had discussion, so I'll call for a roll call vote. And so Member Armijo Pruitt in favor of accepting the findings letters.
No, I would be in favor of accepting all, with the exception of 097.
So you have one exception. Okay. Member Galloway.
No on the current motion with the same exception.
Member Olivas, I'm sorry, Member Mitchell.
Yes.
Member Nixon.
No.
Member Olivas.
No.
Okay, and the board, the chair vote, excuse me, the chair votes no. So now can we go through these and accept the ones that are acceptable? So I would suggest that we have a motion to accept 097-20. Do we have a motion?
So I'd like to make a motion that we accept all of these cases, or that we approve all of these cases with the exception of 097-20.
Second.
All right. So there's a motion on the floor to accept, approve the cases 108-20, 160-20, 175-20, 180-20, 185-20, and 200-20. Is there a second?
Second.
All right, discussion, we've already had discussion. Roll call vote to accept the 7 cases that whatever number, 3, 4, 5, I can't count and talk at the same time. Accept these cases. Member Armia Pruitt,
Yes.
Member Galloway,
Yes.
Member Mitchell,
Yes.
Member Nixon,
Yes.
Member Olivas,
Yes.
and the chair votes yes. So these cases, with the exception of most 97-20, have been accepted. And so we're sending back 097-20 for what purpose? I mean, just to be clear about what we want done with this.
I would make a motion that we send back 097-20 for further investigation and more information provided back to the board as to what that investigation entailed and what it yielded.
I'd second that motion, and I would just add that, Walmart certainly has surveillance video. There's other ways to kind of determine what occurred here.
I would also like to know what policy, standard operating procedures support, the vehicle being parked in that way as well.
So we have a motion and a second to send back 097-20 for more information. Any further discussion? Okay, I'll call for a roll call vote. Member Armia Pruitt,
Yes.
Member Galloway,
Yes.
Member Mitchell,
Yes.
Member Nixon,
Yes.
Member Olivas.
Yes.
The chair votes yes. So 097 is sent back unanimously. I'm sorry, unfounded cases. We're now at the unfounded cases. There are 2 unfounded cases, 076-20 and 195-20. So do I have a motion to accept these 2 cases?
So moved.
Second,
Second.
discussion. I'm looking, I'm sorry. Okay, Member Galloway.
On 195-20, Director Harness, I had that question about, since it's an unfounded recommendation that the agency is making, does the language need to be in there about disciplinary, a disagreement with disciplinary action or taken by the chief? There's two bullet points at the end, or 2 subpoints, 1 and 2, and I think the second one, if I remember correctly, talked about the disciplinary action and if the complainant didn't agree, what the remedies were for that. You're on mute.
You're muted.
Chair Dr. Cass, Member Galloway, for 175, I'm sorry, what's the number?
195-20.
195, sorry.
That's okay.
I see the paragraph that says if you're not satisfied with final disciplinary action decision by the chief. Is that what you're referring to?
Yeah, because we wouldn't be recommending disciplinary action. So for our letter to the complainant, would it be? It was just, that was a question, since we're not recommending anything. Not
Chair
recommending
Dr.
a finding.
Cass, Chair Dr. Cass, Member Galloway, there could be there could be a sustained finding and the chief could make a disciplinary recommendation. This is just a blanket advisement of their rights for a discipline decision that could come from the chief.
But we're not making a sustained finding. We're making an unfounded, right?
That's correct.
Okay. Alrighty, so that was one thing. The other thing is I just may have not understood what was going on. That's entirely possible. But from what I gathered, for the reason for an unfounded recommendation is that Officer H didn't file a report because he didn't conduct his own investigation, that it was taken over by the other officers. So for Officer H's, the complaint against him, it would be unfounded if he didn't do that. But why wouldn't he? If it was two different owners, two different vehicles, each officer was assigned their own vehicle to work, why would that happen? Do you know?
Chair Dr. Cass, Member Galloway, the evidence showed that there were 2 CADs related to the recovery of vehicles. On the one CAD, Officer H was dispatched. A second CAD was also created at the same time for Officer S. There were 2 different stolen vehicles recovered at the same time from the same address, but with different owners. Officer S completed the report and had the CSI process. So Officer S's report covered both vehicles. It would be unnecessary for Officer H to write a report.
Okay, so is that decision just made in the field at the time, that even though they were each assigned their own, one's gonna say, hey, I'm gonna take this over? Don't worry about it, I gotcha. Is that kind of how that goes?
Chair Dr. Cass, Member Galloway, I suppose.
Okay, thanks.
So there was an initial report done. It just wasn't done by this officer.
Chair Dr. Cass, Member Nixon, that's correct.
Other comments on these 2 cases? Member Olivas, you were commenting on this case earlier, 076-20, and I believe you identified a possible SOP improvement. So I guess I would make the same recommendation that we take, if SOP 2-73 is the SOP that's been identified, that we take this up with the policy committee and bring this SOP to the policy committee, and we can have a discussion about it where we might make some improvement.
Yeah, so I'm happy to work on that. So just to confirm, that's SOP 2-73, and I can certainly take a look at that and lead the discussion if that's what you'd like.
And are there any other comments about these 2 cases? I've been informed that I use the word policy when I mean case. So,
Dr. Cass, I have a quick something to point out. It's just that the letter is confusingly written. There's a spot where it says the CPOA finds Officer H's conduct to be unfounded. So I think complaints about his conduct were unfounded, not his actual conduct. And then it says the CPOA finds Officer H's conduct to be unfounded, where the investigation determined that the alleged misconduct did not occur. A report was written in the vehicle processed by a CSI, and it did not involve the named subject officer. That wording, if it confused me, I think would confuse the complainant reading it, but that's my 2 cents.
Do you have some recommended language that you would like to see?
Just his behavior, his conduct wasn't unfounded. The complaint that the complainant made against his conduct was unfounded, right? And then something that maybe just says the report was filed by a different officer. This officer didn't need to file a redundant report. I don't know.
is there a way we can, approve this letter with these language changes? Is that?
I don't think we do that, do we?
That's my question. Yeah.
Yeah, so I was told that we're only approving findings, even though our names are on these letters, we don't really get to say anything about how it's written, and that it gets changed after we make approvals of these regardless. And so we apparently don't get any say over that process. I was just giving my input in case someone wanted to listen.
I think it's good input because I was under the impression we had some sort of standard as far as communication was concerned. It was consistent, and that kind of breaks the protocol, in my opinion, if there is such protocol. I don't feel comfortable having my name on something where, there's just it doesn't follow a format that I can see. I can change at any given moment. That's my 2 cents.
Any other comments, discussion on this?
Our
Chair
attorney has her hand raised.
Chair Dr. Cass, the language for unfounded is prescribed by the CASA, so we're stuck with that paragraph. So that paragraph is prescribed by the CASA and the monitor. So that's verbatim what needs to be in a findings letter for unfounded. I don't know. I don't find it confusing in the context of the letter.
Any other comments?
Ms. Gooch?
Yes, Councilor Gooch.
Thank you, Chair Dr. Cass, Board Member Armijo Pruitt. I just want to confirm a couple of things that I heard in the discussion. The board absolutely has 5 ways it can address proposed findings and recommendations. And the 4th option is return the findings and recommendations to the CPOA for editing, proofreading, or other requested improvements to the draft. So I don't know if that's helpful to the discussion that I was hearing, but I wanted to mention it. And then I don't have access to the letters you all are looking at, but to the extent it's helpful, what Director Harness was talking about is the CASA provision that says what it's required for a finding. And for unfounded, the CASA states where the investigation determines by clear and convincing evidence that the alleged misconduct did not occur or did not involve the subject officer. That's all. Thanks.
So one possible option is to go with option 4, which is to return the letter for language changes. Does that? So at this point, we have a motion on the floor, I believe, to accept these 2 or approve these 2 letters. So without, if there's no more discussion, yes, Member Armijo Pruitt.
Just quickly, does it have to make it come back around to the next meeting, or can we say that we approve it given that they make these changes?
Yes, Council Attorney Gooch, please.
Thank you, Chair Dr. Cass, Board Member Armijo Pruitt. The board by majority vote can choose that option, and it then provides, however, that findings and recommendations returned to the CPOA pursuant to these subsections, which includes item 4, will be returned to the board for final review again pursuant to the subsections contained herein. So I believe the answer is the changes that the board might consider would have to come back before the board at its next meeting before it would go to the complainant.
Any other comment or discussion? If not, I'll call for a roll call vote, and we'll see what happens after that. So the vote is to accept or approve the 2 cases, 076-20 and 195-20. Member Armijo in favor. Member Armijo Pruitt.
Yes.
Member Galloway.
Yes.
Member Mitchell,
Yes.
Member Nixon,
Yes.
Member Olivas,
Yes.
and the chair votes yes. So did I miss anybody? I don't think so. Okay. So this, the cases 076-20 and 195-20 are approved unanimously. So I think we are moving on to the next section, which is the serious use of force and officer-involved shooting cases. And I just have a few things I would like to say before we start this process. And that is that I shared this before, but I would like to share the essentially the flow chart, the process that that APD goes through. So if I could have screen sharing, or if I could share my screen.
Go ahead, Dr. Cass.
Yeah, I'm trying to I can't find I don't see the screen sharing.
I think it's either on the top or the bottom. If you roll your scroll, you scroll up to it.
If you select full screen on your Zoom, and at the bottom, there's a green button in the very middle that says share screen. And if you click that, it should give you your options.
Thank you. Okay, so that appears to work. So, and this is just my attempt to sort of lay out the process that's involved in when a use of force incident occurs. And as I mentioned, I presented this the last time we heard serious use of force. But when an incident occurs, APD goes to the scene and begins their review and investigation according to SOP 257. And if it's a serious use of force where potential criminal charges are, well, if it's a serious use of force, then the multi-agency task force does an investigation in parallel with the internal affairs administrative investigation, and that's shown across the top. And those are actions that can result in either or both criminal charges and disciplinary charges against the officer. If it's a level 3 use of force, IAFD investigates and reports on the uses of force, officer misconduct, identifies deficiencies and concerns with the tactics, training, policy, equipment, and supervision, and then sends that report to the Force Review Board, and that's covered by SOP 2-58. The Force Review Board presents, or this case is presented at the Force Review Board, and the Force Review Board renders its opinion, and that's one of those arrows that comes down to us, and the other arrow is from the executive director of the CPOA, who has his own findings for these cases and presents those as well to the board for review. So then the result of our review is that we can report this to the chief, what our findings are. So that's essentially the process that's laid out in the APD SOPs that are relevant to this. So that, I think that's, if I can give back my screen or unshare my screen, okay. Then I'd also like to mention that it says, I mean, regarding what the FRB, what the language regarding what the FRB determines is that where the FRB determines that an investigation is deficient or findings are not supported by the preponderance of the evidence, the FRB will document the concerns and order an additional investigation through a referral. So what we're getting here is the recommendations of the FRB. And then as one final sort of reminder, and that is that I've tried to put together a process that would deal with this, you know, what our role is in it. And some of the ideas that I came up with, which I'd invite you to, you know, to consider and modify according to what you think is appropriate here. But the considerations, I think, are community safety. Was this use of force necessary to assure community safety? Justice for the individual. Was this use of force within policy? Officer safety. Was the force necessary to protect officer safety? Did it increase community trust in the process, the findings? Were the findings of the reviews consistent with the evidence presented? What were the lessons learned resulting from this use of force, and how did this change training or policy? And then what was learned but resulted in no change? So those are some considerations that I think the board has. And then in addition to that, of course, there's the consideration that the board fairly review these cases. So given that, what we have is 3 cases tonight. There's that are level 3 uses of force. And the first one that I have on the agenda is the case that was the K-9 case. And I think this deserves some explanation as to where, how this got back and what this is about. But as you recall, we did not review this when it was first presented to us back in August. And this was questioned at the board. And my understanding at the time was that this was that the board at some earlier incarnation had made a decision, not in the past, to not review those particular K-9 cases. So that didn't happen back in August. The result was that we followed up on this, and we raised this issue with Dan Giaquinto of the monitors team, and he listened and then said that he would consult with Dr. Ginger to determine if this was appropriate. In the meantime, we also looked back at the minutes of previous board meetings, and we could not find that this kind of decision had ever been made to not hear K-9 cases. So in any case, it was my responsibility to put this case on the agenda when we initially reviewed it from the FRB, and therefore I think we're reviewing this case on the basis that it is considered a serious use of force and should be reviewed as such. So I'll take responsibility for not getting it there the first time. I'm trying to, make this appropriate if that we do review these cases, and we'll, if we get further guidance that indicates that we shouldn't in the future, then we can reconsider at that time. But this, I think, takes care of some loose ends that we had from earlier. So the first case on the agenda is this K-9 use of force, and so I ask Director Harness to present his findings from the Use of Force Review Board, or the Force Review Board. So.
Chair Dr. Cass, honorable board, let me get this up. Come on. Oh, it's. Okay, sorry about that. My review of this case included the computer-aided dispatch, APD field service reports, internal affairs reports, internal affairs force division reports on body recording devices, a review of APD Policy 2-23, use of canine, APD Procedural Order 6-9, Canine Unit, and attending the Force Review Board briefing March 12th of 2020. My review of the evidence shows that on June 4th, 2019, the victim, Mr. D, was observed by members of the Southeast Area Command Proactive Response Team at 335 Grove Street Southeast. Officers approached Mr. D on foot, and he fled into the residence at 335 Grove Street Southeast. They approached Mr. D and advised him that he was under arrest for an active felony warrant. Mr. D fled on foot into the residence at 335 Grove Street and then out the back door and over a fence into a neighbor's yard. Additional officers were dispatched to establish a perimeter. A canine unit responded to conduct an area search. The canine unit arrived on the scene and began issuing pre-deployment warnings. And then a dog search was commenced. Mr. D was located in a city-owned lot on San Pueblo and Zuni. He was placed under arrest, having been contacted and found by the canine. Mr. D was holding a soccer ball when he was contacted by the canine. He used the soccer ball to engage the canine with one hand and with the other hand attempting to control the dog by its collar. Officers were able to place Mr. D in custody and the canine was disengaged. Mr. D was transported to the hospital for treatment, although he did not suffer a canine bite. My findings are that Officer 1's conduct is exonerated in this case.
So is there any discussion, comment by the board?
I would make a motion that we accept the findings of the agency and the Force Review Board at 19-005-1283.
Yeah.
A second.
Especially the fact that they didn't use lethal force. It's good police work.
So
I did have another
go ahead,
comment on
Member Olivas.
two things that I noticed. One was that the report states that he lived at 335 Grove and was attempting to force entry. So he was observed attempting to force entry into his own home is what I understood. So I'm just kind of a little unclear as to the pretext for this stop, even though it seems like the actual use of force was fairly by the book. That was a little bit concerning, though I do understand he had a felony warrant. So I think that resolves that, even though he was at his own home. The other minor issue that I saw, I realized that they did identify themselves as APD officers initially when they contacted him at his home. But when the canine team actually moved in to take custody of him and was giving commands to him, they did not ever identify themselves as APD officers. They just began giving commands. And that is a little bit concerning, as I do believe that's part of policy.
Other comments?
I just had a question for Director Harness. When you did your investigation, at any time did the man say that it was his home?
Chair Dr. Cass, Member Nixon, Member Olivas. Yes, the reports do reflect that that was Mr. D's home. Also, there was some sort of a dispute with the female in the residence who may have locked him out of the house. The recognition by the initial officer was that he recognized this individual and knew that he had a felony warrant while he was outside of the residence. He then fled the residence, so there was no issue as to whether or not entering the premise was exigent, and that was unnecessary. Also, regarding the requirement to identify as a police officer, it is as feasible And bear in mind that over the public address system prior to the deployment of the canine, there were public warnings that APD was in the area. There was a canine was going to be searching, and these were members of the Albuquerque Police Department.
Thank you, Director Harness. That wasn't clear from the short clip that we get. We don't get that that portion of it. So thank you for clearing that up.
Any other comments by the board? Member Armijo Pruitt.
I just want to thank you for putting this back on for addressing the whole issue and putting it back on our agenda. It seems if it's as Director Harness refers to, if dog bite cases are something that the Force Review Board is going to take their time to review, I think that we also should be taking our time to review them. So I appreciate that. Thank you.
Thank you. Anyone else? I have a comment if I see not jumping in too far in line. One of the things that occurs to me is that when looking at the SOP that deals with canines, with this whole subject of canine use, there's very little information about the training or the control that is exerted on a canine once they've been released in a search. And it seems to me that this is something where it would be useful to look at this policy and to see at what point how officers are trained to maintain control over a dog once they've been deployed, because it looks to me like there's a potential serious use of force that is no longer within very close control of an officer. And it was just one of those concerns. I think there's nothing wrong with this case in terms of the policy. What I would think is that the policy is worth looking at. Let's see, Member Galloway, you had a comment.
I just have a question. Did we follow up with Mr. Larson on this? Did we respond back to the email that he had, or is this kind of de facto serving that purpose?
Yes, this serves that purpose, I believe. I believe we initially followed up by reporting where we were in the process of investigating whether this had been a motion that had passed by the board and whether there was some dispensation that came from the monitor. So there was that follow-up, and I think this is it does deserve a response. I think this is the appropriate, an appropriate response. Member Armijo Pruitt.
So maybe I misread it, but I thought he did that in the form of an actual request of an IPRA, which would have required some kind of written response to him, correct? And when I asked Dr. Harness what the response had been, he said there wasn't anything responsive to send because I asked to be included in that. So did we respond directly to Mr. Larson, or?
Chair Dr. Cass, Member Armijo Pruitt, yes, we did respond to a zipper request, and the response was that there was no responsive record found.
Member Olivas.
So I just wanted to make I guess a formal request that we respond to this email. I don't understand why that's controversial. Apparently I'm also not the only member that's asked about this. So I think the amount of time that our director and others in our organization are spending asking if emails about this issue are being responded to are eating up more time than responding to the email would have taken. And I think a simple note of receipt and we are looking into these issues, stay tuned, would have sufficed just to say that we are listening, we are paying attention, and we are actively working on addressing these issues, which I agree with Chair Dr. Cass. I think this largely renders most of the concerns in that complaint moot, but I think that we owe the public that conversation, particularly when they take the time to address the board specifically. Also, if there was another point in there, we can discuss that later.
Member Galloway.
Yeah, I'd just like to follow up and say that I would ask that we do that, that we respond to Mr. Larson with what's happened and the findings of the board pending this vote, just to tie up that communication. But I also think that I know that we have made a request that all at POB email address, communications be responded to within 1 week and a note made back to the board that it's been followed up on.
Any other comments? So I'd like to ask the board what the nature of, what additional response beyond having dealt with the case and having, informed, the public in general with the information that we had at the time we had it. The initial problem arose when we mistakenly thought that there had been an action taken by the board to not hear canine cases. I think once we've resolved that, and by hearing the canine case, it seems to me that the issue's gone away and we've done this as publicly as possible. So I'm looking for what action the board wants to take. But I think I think that's a separate issue from hearing this actual case. And I think we need to make a decision as to whether to accept the findings on this case as presented and then deal with the issue of response separately. So I would ask, if there's no further discussion on this case, that we take a vote on whether to accept the findings that's presented. So seeing no further discussion, and I'm looking, then I would ask for a roll call vote to accept this case or approve the findings. So Member Armijo Pruitt.
Yes.
Member Galloway.
Yes.
Member Mitchell.
Yes.
Member Nixon.
Yes.
Member Olivas.
Yes.
And the chair votes yes. So this case 19-0051283 has been approved as presented. So now I'm not sure this is the appropriate time to deal with the response, but I think it's, I've trying to figure out how best to deal with it in a way that doesn't, that we haven't already dealt with it. And I would move through the other cases and then we can bring this up in other business. I would suggest that we do that. So I'd like to go through these cases. I think they're important and I don't want to be sidetracked by a response to this particular case. So we'll take it up at other business. So the next case on the agenda is I want to make sure I take is case 19-0059410. And this is a new case that was just sent over from the FRB. It occurred in June of 2019. And so I would ask that Director Harness present this case as presented to the FRB. Yeah, you're muted.
Sorry. Chair Dr. Cass, for this case, I reviewed the computer-aided dispatch, APD field services reports, the internal affairs reports, the internal affairs force division reports, the on-body recording device the APD policy 2-52 use of force that was in place for this incident that took place in June, and attending the Force Review Board briefing on March 26th of, March 16th of 2020. Wow, this is not, I'm sorry. Evidence shows that officers were dispatched to, wow, this, I'm sorry. My document didn't save properly, but I can recite the evidence showed that officers responded to 2 people sleeping in a vehicle at Down and Out on Tulane. When the officers arrived, they approached the vehicle and they observed drug paraphernalia in plain sight in the vehicle. The officer woke up the male individual, got him out of the vehicle and handcuffed him. During the custodial search, the subject continued to resist the search, the custodial search after arrest. The officer used a leg sweep to take him to the ground to conduct the custodial search. Because the subject was handcuffed and force was used against him, that made it rise to the level of a serious use of force. This was prior to it being evaluated as a level 2 or level 3. And my findings are that the officer is exonerated in this case.
Any comments from the board? Seeing, I want to make sure I didn't miss someone. I see no comments from the board. So do we have a motion to accept the findings in this case as presented?
I move to accept the findings in 19-0059410.
Second.
Discussion. All right, so asking for a roll call vote to accept the findings in this case. Member Armijo Pruitt.
Yes.
Member Galloway.
Yes.
Member Mitchell.
Yes.
Member Nixon.
Yes.
Member Olivas.
Yes.
And the chair votes yes. So the findings in 19-0059410 are accepted or approved. Okay, the third case on the agenda is case that we heard earlier in August, for which there was a request for more information. This is case 18-012223. And so I would, if we could have a summary or a recap of this case from Director Harness, I'd appreciate it.
Yes, Chair Dr. Cass, this case was previously presented. It involved an incident that took place on the 23rd of December in 2018. Mr. P was operating a white Hyundai. The license plate of the vehicle was listed as stolen. Officer 1 initiated a felony traffic stop. During the felony traffic stop, Mr. P did not cooperate with the commands of the officers on scene. Mr. P discharged a weapon from inside the vehicle. In response, Officer 5 fired 2 40mm rounds in an attempt to break out window of the vehicle. Mr. P discharged his weapon a second time, causing the rear window to shatter. Officers 1, 2, 3, 4, and 5 discharged their service weapons at Mr. P. Mr. P exited the vehicle and collapsed. Officers attempted life-saving measures, but Officer P died at the scene. My findings are that officers 1, 2, 3, 4, and 5's conduct is exonerated.
So are there comments from the board? having had access to further videos and officer statements as requested, I would invite any comments regarding that new information. I can say when I reviewed these videos, this was a very, it was hard to watch these, these actions. And I mean, it's just, it's a very serious situation. I think it was brought home by the extensive, by the large number of videos that are available. And I mean, I just had, I was just had difficulty watching this from start to finish. So, so is there any comment from the board? I would entertain a motion to accept the findings, and we can, from this case as presented by the FRB.
I move that we accept the findings in 18-01-22233.
Is there a second? Now, is any discussion of this case? Member Galloway.
Just real quick, I know that there was that training deficiency and a request for the training academy to look at the one officer with the positioning of the handgun. That's not a policy violation though, right? It's just a training opportunity.
Chair Dr. Cass, Member Galloway, that's correct. It was a training issue, not a policy deficiency or policy violation.
Just wanted to confirm once more. Thank you.
Any other comments? Member Armijo Pruitt.
I know there's absolutely nothing to be done about it, but when we watch these videos and the idea that the suspect or the person that they were engaging with, the citizen they were engaging with in these situations, their faces are not blurred out, but the police officers' faces are blurred out. The police officers' names are taken out of anything we look at. And I think it's a really, I think the contrast when you're looking at someone's dying moments and to the fact that you're actually seeing that on these videos and then, not seeing anyone else's faces, the contrast of that to me was, it was a little bit difficult. I know that we're constrained by the union agreements about whether you can see the police officers' faces, or know their names even, but it does, the contrast of those two things felt like, I don't know, but the dignity wasn't afforded to the folks that were watching die on these videos.
Other comments, discussion? Seeing no further comments, looking, call for a roll call vote to accept the results of the findings from this case. Member Armijo Pruitt.
Yes.
Member Galloway.
Yes.
Member Mitchell.
Yes.
Member Nixon.
No.
Member Olivas.
Yes.
And the chair votes yes. So the findings from this case are approved 5-1. So I would, I'm going to suggest, I'm going to move that we take a break. I believe we're done with the, this is a good place to stop. So let's resume in 10 minutes. So we are resuming the October 6th meeting of the Police Oversight Board, and we are at item 10 on the agenda, reports from subcommittees. So outreach, Member Galloway.
Outreach Committee met on September 29th, 2020. Director Harness provided a status update on filling the CPC, on filling the CPC liaison and admin support positions. There were 112 applications for the admin position, and Director Harness had identified an additional 4 individuals for the liaison position and would be conducting those interviews. I think he spoke to that earlier. The CPC ordinance passed City Council with a handful of minor amendments. CPC Council chairs met to discuss the progress with the CPC guidelines. 4 of the 6 CPCs approved those guidelines, and they're trying to determine how best to move forward since there wasn't a consensus among all of the CPCs. The other items discussed included an update on the executive summary of the CASA paragraphs pertaining to the Civilian Oversight and Community Policing Councils. The media policy, Director Harness suggested that Amanda reach out to Lindsay Van Meter for board resources of the city and what actions the board might consider taking with City Council with regards to the vacant board positions. Director Harness was going to verify that there's nothing prohibiting the CPOA board from more involvement in the applicant review process. And I'll work on drafting a letter to Council President Davis outlining a request for the CPOA board to have more direct involvement on the for board consideration. Next meeting of outreach is scheduled for October 27th, 2020 at 3 o'clock. Any questions, feel free.
Seeing no questions for Member Galloway, I will move to the Policy Committee report. We met October 1st, last Thursday, and our next meeting is November 5th. I submitted a report in writing, but I'd just like to highlight some of the things that we discussed at our most recent policy meeting, and that is we've identified several policies of particular interest which regard interviews and interrogations, SOP 268 and SOP 233, which are rights and safety of onlookers. And both these policies deal with police interactions with members of the public who may or may not actually have committed a crime. Some cases are witnesses, some cases are innocent, just walking around. We've also, the SOP 352 is just about to be reviewed, or the review process is about to be begun by APD, and we have been invited to participate in that review process based upon some suggestions that have been made to rewrite the policy, which is the policy development process. We've also identified training materials that we would like to look at, especially the training module regarding searches and seizures. And I put in a request to the training academy today to ask for those materials, or at least to find out what materials might be available that are reasonable. And also there was a request from the training committee, which is an APD creation, to decide to take public input for what kind of training modifications or subjects the academy might consider. We of the Policy and Procedures Board did not have anything, but we requested to attend the training committee meeting. This will be their second meeting. It's only been in place for a year or so. So, and I put in a request today to see if we could attend their the training committee meetings. I would also note that today the SOP 2-8, on body recording devices, was published, and our request to change the retention time to 1 year was not done. We're not too surprised at that, but I'll just say that the retention time remains at 120 days. So we still have, of course, a letter to the chief that requests a response to why our changes weren't accepted. So that's where that stands. So That's kind of the highlights. If there's any questions, I'll be happy to try to answer them. Member Olivas.
So did I understand correctly that there is already a letter that is that has been sent to the chief on this issue?
Yes, we approved a letter when that was a result of the special meeting that we had in what, now I've forgotten the date, for the specific purpose of approving the changes that were being made to the on-body recording device policy to make it consistent with the state law that was passed, that all agencies would have on-body, it would have cameras. And we, at that time, we wrote a letter that made suggestions as to how that policy could be improved by changing the retention time to 1 year. And there were some other suggestions that was passed in a special meeting by the board.
Okay, I apologize. I recall that. I just wasn't clear on the specific details of the letter being a part of that. Thank you.
Any other questions? Okay, we're at who's next here? Case review, Member Galloway.
So we did not meet in the month of September, but we are scheduled to meet October 27th at 4:30 to discuss the third quarter audit of CPC case numbers 14720, 15520, and 16920. The cases were submitted to Director Harness and files have been made available to CRC.
Questions? So Personnel Committee, Member Olivas.
Thank you, Dr. Kess. We did meet last Monday on September 28th, and we will be meeting again on October 26th, which is also Monday at 3 p.m. Most of what's contained in my report, I think, is something that we'll be covering in one of the next agenda items, so I'm not going to belabor that, only to say that we've been working quite a bit lately, and certainly at our most recent meeting on perfecting and accepting further input on the director's evaluation process for 2020 and 2021. Hopefully you've all had a chance to review the materials that I've made available to you, and we'll be discussing that more later. The other item for update is on the 2019 evaluation. We have sent out those evaluations. Hopefully everyone that is going to be receiving them has received them. Not every member is going to receive them, because if you weren't on the board at that time, you won't receive a survey. But please complete those surveys. Hopefully you already have, but if you haven't, please do it as soon as possible so that we can complete that process and begin actually analyzing the data. And our hope as a committee is that perhaps if everything goes smoothly with collecting this and everyone gets their input back to us, we may even be able to present that evaluation at the November meeting. So that's pretty much where we stand. Again, next meeting is October 26th. Thank you.
Thank you. Any questions? Seeing no questions on that item, we'll move on to item 11, discussion and possible action items. So the first item there is the executive director's evaluation. Member Olivas, I think this is yours.
Thank you, Chair Dr. Kess. So a couple of things here. First, to start out, I just wanted to thank members of the Personnel Committee, Chair Dr. Cass and Member Mitchell, for all of their work and input on this issue that we're finally here with a draft presentation to the board. I also wanted to extend a special thank you to Member Galloway and other members before that have been involved in drafting these evaluations, because while it may look very different from past evaluations, it's very much a building block on those that came before it. So I think that we owe credit where credit is due to those previous iterations of an evaluation. And we appreciate having that to lean on as a committee, and myself as the chair of the committee. And also thanks to the input of our staff, Director Harness, and several of our investigators have also been involved in giving us some input on this. And it's been a very long process here of actually drafting this, but I think we finally have something that is in very good form, I believe, and the committee, I speak for the committee in saying that we strongly recommend this to the board for action tonight to approve the evaluation process. There's quite a few materials that you'll have noticed. Hopefully, as I said before, everyone's had a chance to review these. You should have seen them several times and maybe even for several months, as I sent them out right after our last board meeting, so everyone would have plenty of time to take a look at them. At our last meeting of the Personnel Committee, we asked Director Harness for his specific input on the evaluations and the surveys and the matrix and everything. And actually, we did not get any input. He was, I don't want to speak for him, but to paraphrase, he was satisfied that this was a fair process that he felt was useful and was fair. We got very little other input at our most recent meeting, but we did make some changes as suggested by Chair Dr. Cass relating to some of the language in the changes to some of the language in our proposed amendments to the policies and procedures. So the most recent version that you've got from me should reflect that. I don't think these will be seen as anything other than fairly germane edits, changing some language and removing some language that we felt was no longer applicable to the process. But I think that overall we've got a good process defined. This our amendments, which I know we'll consider later on, but I do want to kind of start with that. Our amendments do define how the process works from a time and date standpoint, in that we're now formally defining when the process begins and what it begins with, when it ends, when certain meetings are to be held, when certain presentations are to be had. And as a committee, I think we felt that was important to have those dates as guideposts for the committee and for the board, so that these are done in a timely manner. And so that's really what a lot of those amendments deal with, is just laying down those markers as to when certain goals are to be achieved. And when I speak of goals, I'm speaking of goals by the board in implementing an evaluation, so that these are done in a timely manner. Other materials that you'll see there, you've got a matrix, which is actually the statistical data collection tool. The meat of that, of course, is aggregating all of the data that we'll be collecting in this process, from surveys, from data that may be produced through the annual reports, data that may be collected from the agency directly, and that aggregates all of that data and calculates that into scores for different metrics. And of course, those metrics actually range. We have several different categories. This is based on some input that we got from Member Nixon, really regarding competencies, core competencies, and this is kind of what we arrived at. Purpose and goals, transparency and ethics, communication, staffing and management, budget, board, complaints, internal affairs, and an overall rating. And then within each of those categories, we have different questions, or what really I think we should refer to as goals within a category. So this defines very clearly what those goals are and asks for input from the different stakeholders, which in most cases are staff, board, the director himself, him or herself, and any other outside evidence that may be considered. I know I got some questions from board members in the intervening period about what those pieces of evidence might be, and just keep in mind that one of the goals of this is to remove asking members questions such as we are on our current survey. We have like a question about our agendas posted in a timely manner on the website. And it was kind of our feeling that that's not really a question that we need to ask board members about. It either is or it isn't, and the data can speak for itself. So those are the sorts of things when we're talking about direct evidence, those are the sorts of things that refers to. And in general, in our proposal, those would be analyzed and collected by the personnel subcommittee and synthesized into a number for that matrix. I think another key point of this evaluation is that we do take into account the director. The director is able to give feedback on his or her performance. The director is able to give, in many cases, they're able to answer the same questions as we are as board members, as staff members are, so that there can actually be a comparison as to how different groups might feel about different issues. So that's another change that we've made here in adding that third survey. And the surveys are very similar, but slightly different. Some of the wording, obviously, different audience, different wording. And then there are some questions that are specific to an audience that, perhaps staff doesn't know anything about certain questions that the board may be asked and vice versa. So I think it summarizes some of the major changes. Another question that I got and may come up again is on the weighting within this matrix. So there's a good deal of math here that goes on within this, but the point here being that we are going to be weighting different responses based on what we've determined as a committee are the perceived, trying to think of the right word here, but perceived relative importance or relative knowledge of a particular subject group on an issue. So there may be certain issues where, again, the board is going to receive more weight because perhaps they have more information on a certain question, and vice versa, the staff may have lower weight in that question. But every question may or may not be weighted differently. Some have exactly the same weights, some have different weights. But point there being, again, the director may have 10% of the weight on that category, 50% to staff, and 40% to board to get a 100%. So I think that's where I want to go as far as introducing this. Really want to open it up for questions and comments from the board. And again, our hope here is that with the changes we've made, this will now be a front-loaded process instead of a back-loaded process, so that we will be basically ready to go when the evaluation period ends, so that we can actually produce an evaluation in relatively short order and in consistent fashion, so that the director can be evaluated frequently and effectively and fairly and with input from all of the stakeholders. And I think this also gives us more data to fall back on, to look at where there may be performance issues or where there may be shining examples of really good work. I think that's another important thing that this has the potential to show us where things are good and where things are bad. And that's what any evaluation does. But I think we're building on what we had to make this better. So I'll leave it there and open it up for members and staff to comment or question. But I guess at first I need to make a motion to accept the evaluation process and documents as presented to the board in my email.
Second.
Okay.
All right, so there's a motion on the floor to accept the process and the documents as presented by Member Olivas. Is there any discussion? Member Galloway.
Kudos to you, Member Olivas, and to the rest of the Personnel Committee. This is obviously a lot of work that has you guys have undertaken. So just looking through this, on page 3 of the evaluation event timeline table, number 18 lists training, networking, and continuing education opportunities provided to staff. I know that you and I discussed this, Eric, and Director Harness alluded to it earlier, but we probably need to have something that captures that some kind of testing module has been provided to board members and staff following these training events. Is since that's something that the monitor has requested of us. Just
Yeah.
flipping through the pages.
Can you point me to that reference again? What page?
Yeah,
that was?
page 3
Second.
of the evaluation. Oh, I'm sorry. Is that your question?
Yeah, just what you said, page 3 of which document?
Of the evaluation event timeline table. And it's, it caught my attention at number 18, but it's just a piece that's missing period that I think is worth consideration.
Sure.
Since it was brought up in an IMR. Let's see. There are a couple of questions in there that I kind of referenced, noted to myself the same concern. Minor edit, I don't know if you care about that. On page 4 of the CPOA staff survey. You double check and make sure, yeah. It's section D, staffing, training, and advancement. Number 3, because this is going to the staff, perhaps it should be, I have been accountable for achieving tasks within my job description. Same document under E, the budget. The director is a good steward of agency funds. I don't know how staff will be able to gauge that. I could be wrong, but that seems like a director and board thing. Page 8 of the same document. Is this meant for, it's the complaint process, is this meant for all staff or just the investigative staff?
Sorry, I'm trying to take notes on your other items here.
I can send it to you too.
Yeah, that would be great so that I can make sure I capture the edits, since I think those are generally germane, some of those. As far as staff that would be considered, I think this really applies in my mind to all staff, because a lot of these questions aren't necessarily specific to anything related to an investigator's work, something like I'm being held accountable for my actions or for my job description. I think that applies just as much to an admin assistant as it does to an investigator.
This one is specifically about the complaint process though.
So
Same.
Which question were you referring to?
It's on that same document that I've been in, the staff survey one. It's item G. And the question is all staff or just investigative staff, because it's the complaint process. And I know that things are changing within the agency as to where previously some of the admin staff that are not investigators were receiving complaints, but I don't know if that's the case now that Diane has taken over as lead investigator. I know she was planning on changing some things up.
So I think you raise a good point there, that I guess we can certainly discuss as a board whether we want to restrict some of these sections to investigators or not. There's also the other option of adding, and I think, well, I guess it's not specified in this, but there's also the option of adding a NA or I don't know type of response, where the data just wouldn't be collected if someone didn't feel comfortable answering that. So there's a couple of ways we could proceed there that I guess we can decide what we want to do. I think that's a good point.
Okay. Excuse me. On the board survey, let's see, on page 4 of the board survey, number 2 says the director will hold staff accountable for achieving tasks within their job description and other tasks assigned to them. We don't have any oversight of the agency staff as a whole, only over the executive director. And so I'm wondering how appropriate it would be for us to evaluate on the remaining agency staff's job descriptions and whether they're being held to it. So that's more of a discussion point. But it's very clearly defined that we have oversight over the executive director and the executive director has of the staff. So it may just be some finessing of the point that we're trying to get. But I think that the way that this is worded, we would need their job descriptions and, you know, some kind of a report as to what's being assigned to them. And that's a little more micromanagey than I think we've ever been in the past. I don't know if we need to be, but yeah, that. And that may be it as far as those things go. The evaluation matrix guidance, the summary page, the overall rating score will be determined as follows after averaging the score within each survey group. 10% to the ED, 50% to staff, and 40% to the board. Does that mean we're going to weight everything else, all of those subcategories, and then from that, we're then going to weight the totals of all of those according to this?
So what that's referring to is an overall rating. So within the matrix, if you actually look at the matrix in the very first page, there is one portion which is only 2.5% of the overall score that is basically related to I think it's the last question in each survey, which is rate the director's overall ability to manage the agency, or rate your overall opinion of the director. So that's referring only to that specific question, which is sort of an overall, how do you feel about the director? So it's not the whole survey. Each question actually has its own weighting. So if you go further through, you'll see each question and then within each category.
Right. I just wasn't sure if that was going to be an average of those averages. So, okay, I think that's it. Thank you so much. Again, this is awesome.
And I just wanted to say about the staff accountability question. I think, again, you raise a good point there as to sort of how we finesse that. I think what I was getting at is the need to hold the director, and this isn't specific to the current one, any director, accountable for managing staff, right? That's the director's job, or one of the director's jobs. So I think that's what I was getting at there. And like you said, it may be getting a little too micro level when we're saying according to their job descriptions. So maybe there's a way we can wordsmith that to take a more 10,000 feet approach versus, you know, is a specific job description being met? So I would welcome that change.
Any other comments from the board regarding this item? So how would you like to proceed, Member Levis? Do you want to vote on for all of these documents to be accepted as you've presented them, or with editing modifications? We can trust you to, or we can trust the Personnel Committee to make these modifications. Or
so I did want to go through at least, I think I see, I'm trying to read through my notes here, at least two of these that I would like us to discuss as a board, just to kind of see where we want to go. And it could just be very quick discussions. I'm not sure, you know, how we want to do that, if we want to vote or if we want to just sort of make the will known. But this issue on that staff accountability question, I think warrants a little bit further investigation or discussion. Also, the question that Member Galloway raised about the complaints, that complaint section that's in the staff survey, and whether we want to focus that just to investigators or if we want to broaden that to everyone. If we do so, do we want to give the option of NA doesn't apply to me, or I don't have enough information, that type of thing?
And so could we be clear which document are you referring to right now? So if we're gonna take these individually, I just want to make it clear for our viewing audience and everyone else what document we're working on.
So let's take the board survey. So this would be the survey that will be sent out to board members, just like the one that some of us have received now for 2019. This will be the board survey, and let me pull up that specific question so I can read the current text. Member Galloway just read it, but I'll do that again. It's section D of the board survey, ED Evaluation 2020 Board Survey. Section D, staff training and advancement, question number 2 reads, currently, the director will hold staff accountable for achieving tasks within their job description and other tasks assigned to them. Do we have a suggestion on how that might be improved?
If I may.
Absolutely.
I think that probably the easiest thing would be at subcommittee meetings, having tasks assigned. I won't say all committees. The committees that I have been a part of in the past have not done a very good job of assigning a task to either a member or to the agency, and for the agency to delegate out to whomever Director Harness sees fit. If we were to do a better job of keeping track of that kind of stuff, if a task is delegated to a staff member and we don't have the results from that task within the time frame, that would be one way that we could do it. That's common knowledge without us getting too deep in the weeds.
Yeah, I think my only concern there, well, then again, all of us serve on different subcommittees, so we have that knowledge of who might have been assigned what. But I guess, I don't know, just off the top of my head, I'm kind of leaning towards actually removing this question entirely just to make it cleaner. I think the only people that truly know if they're being held accountable are the staff themselves and then the director, if that's happening.
That too.
Anyone else have a preference here as to what we do?
I agree with removing it, actually. I think that it's asking a little much for us to have insight into the inner workings on that level. And I think that in the surveys that ask the staff how they feel about, the clarity of the expectations for them and all of those things, that makes sense. And that's, I think, the best place we're going to get sort of a view of that part of that process.
So would we be okay with removing that from the board survey and reweighting that to basically being something like a 90-10 or a 90-20 or an 80-20? So majority weight there going to the staff and then a small portion of that to the director. Okay, so it seems like we have consensus on that. The next question, let me jump over to this document here, which is going to be the ED Evaluation 2020 staff survey. And this is in section G, complaint process is the heading. And basically this asks a series of questions such as the director has outlined a clear and consistent process for investigating complaints. This is question 1. Question 2, again, these are being asked of staff. The director has designed an efficient process for investigating complaints. Question 3, the director has designed a complaint process that is fair and transparent. And the last question in this category, the director's complaint process emphasizes analyzing and addressing policy and training deficiencies to improve outcomes and achieve long-term department-wide improvements. So the question that we've been asked to answer here is essentially, do non-investigative staff have knowledge of this, any or some, and then how do we want to have them participate in that if we do want them to participate in this section?
It seems reasonable to me to just put in A, it's not applicable, rather than redrafting the document. Just add that piece. That'd be my thought.
And I think it would add some challenges to distributing a survey if we then have to kind of distribute a separate survey to non-investigative staff and investigative staff, and then kind of adds another layer. Member Armijo Pruitt, I think you had your hand up.
I agree with what Doug said. I think that having that option of NA or I don't have the exposure to know, would suffice.
And I think that sorry, I didn't realize my video got kicked off there. I think that goes for any of these questions, really. I think that was included in the last iteration, this 2019 one. So it really goes for any and all questions where, in general, you have that right to say, I don't know, or it doesn't apply. And that was an oversight on our part in not including that, but we certainly will in further. So I think that solves that issue. Member Galloway, was there another one? I have an incomplete note here. I'm not sure.
The budget piece in the
Yes.
same survey was the other one. But just real quick, two things. I think Tina has her hand up too, so just so we don't lose her. And then also, is this an anonymous survey going forward?
Yes, it would be anonymous, just like the ones in the past go. And I think that's written in there somewhere. There's been so many versions of this, it's hard to keep track of. But I think that the language, sort of the introductory language, would be very similar to what you got in the 2019 version. Saying this is anonymous and all names and that sort of thing are redacted. So, yeah, Councilor Gooch, if you want to jump in here before we get to that question.
Thank you, Chair Dr. Cass, Board Member Olivas. I want to point out that you have already accounted for much of the discussion about the non-applicable choice in your introduction that you were just referencing. If you go to the first page of the staff survey, what you've provided in this draft says if you do not have an opinion on a question or you do not feel you have enough information to answer the questions, please skip the question. So I do think that you've accounted for that in your actual introduction. To the extent the board thinks it would be more helpful to have an NA to circle, that's within the purview of the board. I personally find that if I have that choice, sometimes I pick it because it's there and when I otherwise might not have. And then in addition, you also clearly point out in your introduction that answers and identities will be confidential. So you have addressed those things. I know you all have been working on this very hard, lots of iterations, but those are both there already. Just to point it out for everyone.
Forgive me.
On surveys like this, well, any rubric or metric you're going to use, the NA serves also as an indicator when you're looking at different versions. You may have one version that you're using and it goes live, for lack of a better term. And then as you get feedback on that survey, especially over time, maybe it's 24 months, maybe it's 1 year, you will find patterns of questions that aren't applicable. So the NA helps you to kind of guide the versions of whatever survey you have, so that you can either omit or change questions as it goes along. Once you see a pattern of a certain question hitting NA all the time with folks, then that brings into question when you do revisions whether or not you want to address that particular question. So I think it's good to have NA in there as a strat. I understand what Tina's saying because it is tempting to select it, but I think in this case, especially when you're starting in the beginning stages of a survey, you definitely want to have NA in there. And once you get a couple of revisions on you, you can remove it, but I think it might be good to keep it.
Yeah, Member Pruitt.
So I agree that you should keep NA for the reasons that Member Nixon stated, but also personally, if you have a question that I think if you require all questions be answered, then you will answer the hard questions and not skip them if they feel like, oh, I'm not sure what I want to say about that or whatever, but if you have to answer every single question in some fashion, I think it holds people to actually answer all the questions. Sometimes if you can skip one, that means you could skip another one just because you're not sure what you want to say or because you feel uncomfortable about it or whatever.
Yeah. And is NA thrown out, or is there a weight associated with an NA? You have that choice to make too. Take into consideration.
Yeah, I think that sounds like we're in broad agreement that NA is the right way to go. And that was probably just thinking about drafting that statement that just didn't pop into my head of NA. It was more of skip, but same idea, but just different mechanism. And I think we will definitely move that direction of using NA. And as far as weighting that, I think the only fair way to weight that is to essentially not consider that it wasn't answered. It's not a 0, it's not a 5, right? It's not there.
Agreed.
So, and then I think that maybe, Member Galloway, that might address the issues with the budget section as well. We can have that conversation too, though, if we want to remove the budget section entirely from the staff survey. But in my mind, I guess where I was thinking about this was sort of staff may have information about profligate spending habits or activities or poor budgeting decisions that we as the board may not have or may not know. And so that question could, to certain staff that may be purview to that information or may have that information, could give the board information that it wouldn't otherwise have. I'm not saying this is happening. I'm not saying it will happen. I'm just saying it allows that feedback to come to us. And as Member Nixon said, if we start getting that all of those are coming back as NA, maybe we just leave it as do you have any comments about this or something like that as future iterations of this go through?
And I think that's fair. I think looking at this question again, because it was really only question 1 that I was concerned about. Because question 2, they would know whether or not resources that they need are available to them. So it was really only that first one, but a good steward of agency funds is different than actually adhering to a budget that is set up. And I think that that's where my mind went initially. So
we may be okay with that, particularly in the light of NA being an option. Okay, so to sort of summarize our discussion here about changes we seem to have consensus, unanimous consent, let's call it, on making. That would be to change that introduction so that we don't use the verbiage skip and instead use NA. And that applies to all the surveys. So we'll make sure that that's common across both the director's survey, the staff survey, and the board survey, that's included, NA, not skip. And that then solves our questions around the complaints and investigations, whether that applies to different staff members as well as budget. And then as far as the staff accountability question under management, staffing and management, we will remove the board from that. We'll remove that question from the board survey and reweight that category to emphasize staff input on whether or not they're being held accountable for their actions. Any other comments? Also want to give another opportunity for our Council Gooch or Director Harness to weigh in with any other observations or suggestions. So hearing no further anything, I guess this kicks it back to Dr. Cass as far as how we want to go forward here. I would propose that we basically consider this as a suite, since it seems we have fairly strong consensus here, to just consider the whole package. And I don't think it makes a whole lot of sense to adopt one at a time. One doesn't really work without the other, right? You can't really send out or approve one survey and not the other, or one matrix and approve the matrix and not the surveys, kind of thing. And another thing that we've emphasized at the committee level too with this stuff is we want to, I mean, this is contradictory. We want to emphasize that this is a defined process, right? So that the director is held accountable. There's a clear process. There's clear goals and metrics. But at the same time, I think we want to say, this is our first iteration of this new process. And if there's issues, we will address them in a fair and transparent manner. And there probably will be, whether it's that the wording of a question isn't good or just something doesn't work, we're going to find that out and we'll fix it and we'll bring it back to the board or inform the board and make the appropriate changes so that the process can be improved. And that's the idea here, kind of as Member Nixon says, as we make further iterations of this, we'll realize where the problems are, where the bad questions are, where the things are that are going to cause problems. And another feature of this that I didn't emphasize, but is in the changes to the guideline, to our policies and procedures, is a meeting with the director at 6 months regarding the evaluation. Basically just to kind of look at these goals, look at the kind of questions on the survey and say, hey, is there anything here that's standing out that you need board support for, that we need to be aware of, where we may need to modify something or change something, to kind of give that proactive look. And then before this is actually formally adopted by the board, we give another opportunity for the director to, again, give input. It doesn't mean that that's going to be accepted, right? Because only the board can make that decision. But again, if there's something, clearly the stats were done wrong or something is transposed or anything like that, gives that an extra check. And that was a big piece of feedback that we got from the director, was that he didn't feel like he had input in the current process. And so I think this gives a few different ways for that to happen in a meeting.
So can we deal with that separately at the time when we do the modifications of the policies and procedures. So it seems to me that the motion that you have on the floor is to accept this set as a suite of documents, and I would recommend, or I would suggest, that maybe there should be an amendment to your motion to say as amended or as edited according to the board input tonight. And then we could, so if there was a friendly amendment to accept the edits that the board has made tonight, then they could be taken back to the personnel committee, or it could be accepted as edited, and you could present those to personnel committee, and we could make sure that worked out. So I would suggest a friendly amendment to this to accept edits as presented. So do I hear an amendment to Member Olivas' motion to accept these documents?
I'll make that friendly amendment.
I'll second it. So is there any discussion on the edits that we've talked about? So seeing no further discussion, then I'd like a roll call vote for accepting the amendment to approve the amendment that accepts the edits that the board has made tonight, and that Member Olivas has or will have sent to him by the members. So all in favor, Member Armijo Pruitt.
Yes.
Member Galloway.
Yes.
Member Mitchell.
Yes.
Member Nixon.
Yes.
Member Olivas.
Yes.
And the chair votes yes. Now we have the suite of documents as amended or as edited according to the amendment. So is there any further discussion on accepting this suite of documents? Seeing no further discussion, I would call for a roll call vote. Member Galloway, did you have something more?
Yeah, I'm so sorry. Just, did we run this by the attorney at the city with HR? Just out of curiosity.
So it was run there in a very early iteration of this. So that was one of our first sort of consults at the committee level. And so I think that one of the things about this too is, since we have some time before the actual evaluation period closes, we can certainly do that, especially now that we have sort of we have real guidance from the board on that this is the direction it wants to go. So I think that's a good next step after these minor edits.
Thank you.
Any other discussion before we vote?
And I would just add to that maybe we can request that Councilor Gooch also take I know she already has, I'm not sure how extensive of a look she's taken at this suite of things, but that may be another thing that we want to ask for.
The attorney at the city is free to us, I believe, and Tina's time is not.
All right, any other discussion before we vote? All right, all in favor of accepting the suite of documents as amended? Member Armijo Pruitt,
Yes.
Member Galloway,
Yes.
Member Mitchell,
Yes.
Member Nixon,
Yes.
Member Olivas,
Yes.
and the chair votes yes. So the suite of personnel documents for 2020 is approved unanimously by the board. So moving on to item B under discussion and possible action, the ad hoc working group memorial. And I'm not sure who's responsible for this, but if there's action or not, I would like to hear from somebody from that group. I believe that group is members Galloway, Member Nixon, and Member Armijo Pruitt. Is that correct?
I think Member Nixon, and if it's all right with you gentlemen, I would ask that we table this since we've not met yet.
Yep.
So if you need, just make
Make a motion to table.
Yes.
Second.
All right. Any discussion? All in favor by roll call? Member Armijo Pruitt,
Yes.
Member Galloway,
Yes.
Member Mitchell,
Yes.
Member Nixon,
Yes.
Member Olivas.
Yes.
The chair votes yes. So the motion to table item B is passed unanimously. Item C, CPOA board membership update. I'll take this item. And this is not for action, but strictly for discussion. The question was raised about the status of Member Starr. I have tried recently, last week, I put in calls to the 2 numbers that I have for her and that I've used before to try to reach her, and I have yet not heard any response from her. I did do a look at the minutes, and she's been absent from this meeting, of course, September 10th, August 27th, August 13th, and July 9th. And I believe the July 9th meeting would be considered an excused absence because this was at the beginning of her, when she was first having health issues. So this is essentially all I know about the process. And I think that, at this point, the easiest resolution to this is to ask again to try to contact her and find out what her desire is to stay on the board. If we don't, I think we can make a good faith effort to do that these next, between now and the next board meeting. And if we hear nothing back, then I believe it would be put on the agenda to report that she's missed at least 3 consecutive meetings. So this is what, I think the status of the situation is. If there's any comment or discussion, I'd, be happy to hear it. So Member Armijo Pruitt.
I'm just wondering if anyone's had any contact with her to make us believe that this is something she's still interested in.
So she was pretty responsive to me for a while, but that stopped well before our last couple of board meetings. So I think that she's gone. I think she's missed a special meeting and 2 regular meetings outside of the one that could be considered excused. And I think it's time to call a spade, to be honest.
Member Olivas.
I do believe that our guidelines actually say that after 3 unexcused absences that we would report that to the city clerk, that this individual was no longer on the board. I think it makes it actually an automatic removal, if I'm interpreting that correctly.
And at this point, I would ask Council Gooch to, fill us in on the language of that or the details and give us her, render us her legal opinion.
Thank you, Chair Dr. Cass, Honorable Board. The ordinance provides that the appointment of any member who has been absent and not excused from 3 consecutive regular or special meetings shall automatically expire effective on the date of such absence. On the date the fact of such absence is reported by the board to the city clerk. The city clerk shall notify any member whose appointment has automatically terminated and report to the city council that a vacancy exists requiring an appointment for the length of the unexpired term. So that is what the ordinance provides, and your current policies and procedures provide that as well. They've adopted the ordinance in full. As we sit here tonight, there isn't an action item to make the finding or point out to the city council of the fact of such absences. But that's something that the board can easily add to its agenda for next month or the next meeting to take action on that. An alternative reading could be that those absences are unexcused and therefore there's no action for this board to take, that instead it's just an automatic notice that the board, through either Dr. Cass or Director Harness, provides to city clerk. Given that no one has heard from Member Starr, given the number of unexcused absences, I believe that the board could go either way. I know that you aren't very quickly having empty seats filled as we sit. So I don't know that taking action tonight versus waiting until your next meeting to give Member Starr an opportunity to contact one of you, quite frankly, is going to matter given how long the process takes and how you haven't had a full complement of your board in years. But anyway, I do think you can choose. I would recommend that you put it on your next board meetings agenda, just to give her the opportunity to reach out, resign, hopefully not, hopefully provide somebody an update and get back on track with you all.
Thank you for that. So
I would recommend that we notify the clerk and we just deal with this and move on. I mean, it sounds like there's been several opportunities for her to reach out to us. She's made no effort to do that, apparently. And I do think a board member has a responsibility to keep the chair informed of their absences, especially if they think they're going to be necessitated over a long term. And so I think based on that and based on the reading by council, I think we notify the clerk and we just proceed.
I agree, and I hope she's okay.
So I think we can put that in, I believe we can put that in the form of a motion to, is that appropriate? Or if, I mean, this is, we're in kind of a dilemma here. The question is whether this is an action, whether we have this in the agenda as an actionable item, or if it's necessary, as you mentioned. So if there's, if it isn't an actionable item, then, and it's an automatic process, then there's no further action required by the board, correct? I mean, having heard what I've heard tonight, we can notify the clerk.
Chair Dr. Cass, Honorable Board, that is correct. You've certified, you've researched, I don't hear any objections to anyone about the absences or an incorrect or error in that. And so automatically, yes, that notice can just come from the board through its chair with no need for a vote.
Would it be appropriate for the board to vote with their approval of, that this be, I mean, is there any way to sort of go halfway on this and let the board at least go on record as to how they, how they would want this matter handled?
Chair Dr. Cass, Honorable Board, I believe that you can take that discussion and ask board members without actually having an action item or a vote, if that is what the board would like to do.
Well, I
Can
mean,
we
I-
actually vote, Tina, though, since it's under discussion and possible action?
Chair Dr. Cass, Board Member Galloway, no, but you also don't need a vote. I believe that Dr. Cass was more looking for the temperature of the board or an opportunity for the board to weigh in on this particular item. I could be wrong, but there's no need for a vote. It's just a matter of reporting the absences to the city clerk.
So I would like to let the board, express its, to go on the record, with some, in the form of a resolution or however we do it. But if we can, I don't know if we want to call it a vote, but I would ask to poll the board as to whether they feel the chair should notify the city clerk that Member Starr has missed 3 meetings. So I will poll the board. Member Armijo Pruitt.
Yes, I think that just to add in there, it takes them so long to get new members vetted. I think it's better to get that information to them as soon as we can to get things rolling. So yes.
Okay, Member Galloway.
I love it when the space bar doesn't work. Yes.
Okay, Member Mitchell.
Yes.
Member Nixon.
Yes.
And Member Olivas.
Yeah, echoing what Member Nixon said earlier, I hope she's okay, and appreciate her service while she was here.
Okay, and so the chair will go through the proper notification procedure. I'll rely on council to guide me on that. So next item on the agenda is the chief qualifications recommendations. And this was as a way of introducing this subject. This was a letter that was composed the last time a chief was being sought or searched for. And the board went on record as to what the qualifications should be. There were a couple of different attachments that were sent out by Director Harness. And I would invite him to, discuss what it is that what these recommendations were and what the basis was. So Director Harness, if you would be so kind as to inform us as to what happened the last time you tried this.
Certainly, Dr. Cass, thanks. Yes, as Dr. Cass already stated, during the last search for a new chief, the board tasked the agency and Dr. Verplu, who was our data analyst at the time, to come up with some minimum qualifications to be the chief for consideration by the mayor who does the appointment. And it was done in a recommendation because there was actually at the time, there was actually a policy, 3-1, and then it morphed into 3-10. And so the board sent the letter to the mayor and the city council and to the chief to make the changes to the qualification, to the chief's consideration, I think is the policy. As I open this up again, I'm sorry. Yeah, selection, authority, and responsibilities of the chief of police, which was 3-10 at the time. And when in my previous experience as a volunteer police commissioner, where we were in charge of hiring the chief for the village, essentially 3-10-3, which I've provided to you, 1 through 6, were the minimum criteria for an applicant to even apply to be the chief for our village of only like 12,000 people. But I think that these are pretty standard qualifications for consideration to be a chief. And I would urge the board to review these and perhaps because this is going to be a lengthy process as described by Attorney Van Meter, review these and consider have the board consider taking a position for the minimum qualifications of the chief to be considered by the mayor and the city council.
Thank you. So is there any comment by the board?
I would echo what Doug said earlier, as far as also inserting ourselves in the process in this, this selection committee or whatever they're calling it. I think that certainly it seems logical that the board have a seat at that table and in that conversation, given its representation of the community in multiple ways. And then this recommendation that was previously considered and as presented by Director Harness right now, I think is, obviously seems to be some very basic minimum requirements. I mean, they're not basic in that they're easy to meet, but in that, that makes sense. And it's kind of shocking that isn't already the case.
Member Galloway.
I guess I would agree with that, specifically that last sentence. Do they not have something like this in place already for searching for a chief of police? Do we know?
I did a little bit of research on that in that I looked for an SOP I'm not sure the SOP that existed, how long the SOP existed before that dealt with, hiring a chief or the chief's responsibilities, but there was an SOP 3-1, I believe. But I could not find any SOP that dealt with the chief qualifications that currently exists in Power DMS. And I did a search. So I think the answer to that is it was decided that the APD was not going to weigh in on this because this was the mayor's decision.
So is this proposal, Director Harness, to become an SOP or just to give to the search committee as a guideline?
Chair Dr. Cass, Member Galloway, I think that I think it should probably come out as a position statement from the board, because it is a mayor's appointment, which now is done with the advice and consent of the city council and not governed by APD policy any longer. So I think it's a position that the board should adopt and move forward as the candidates are considered and brought forward to help the public, with some guidance and some clarity as to standards and qualifications for the chief of police.
And that goes then back to my original question. Do we know if they have anything like this already that they're working on or working with?
Chair Dr. Cass, Member Galloway, we never found any minimum qualifications in our initial research.
Okay, thank you.
So moving forward, I would suggest that what we do is all members we can start with this letter that was sent from created by the previous board and agency. And if you have modifications or suggestions, you can send them to me and I will work with the agency to draft a new letter that updates this to what this current board thinks, and we can have a consideration of that at our next meeting. So that's my suggestion. If you have, I'm entertaining other options. Anybody else have a suggestion?
I strongly support what is drafted here, and if I do think of other important qualifications or those are made known, I'm happy to consider those. But I think this is a great start.
And I think what we're after is just updating this to the current situation and allowing the board to weigh in with its own input into this so that, it represents what we think the situation should be, or the qualification should be. So I take your comment as an endorsement that of what I suggested, that I'll roll up any comments from the board, and we'll create a draft of a letter that we can present to the board at the next meeting. So with that, I will move. I think we've discussed this item. It was not here for action, so we'll close it out and move on to the next item on the agenda if there are no further comments. So seeing no further comments, I would move to the approval of the policies and procedure modifications. And this is a big task that our council has graciously accepted. And so I'm going to let her wait around in this for a while. So it's all yours.
Thank you, Chair Dr. Cass, Honorable Board. You had received in your board packet a redlined, coded policy and procedure. And thankfully, there's only two parts of it that I want to raise for the board's consideration tonight. And I want to point out that the yellow is simply there for the monitor team for once we finalize this, for them to review the ethics policy that we are, had been waiting on them. We had those technical edits to it that the board voted on last month. And that is simply still in yellow, not for any action tonight, but just so that it's easy for the monitor team when we are able to get this to them. The two areas that I need the board's guidance on are in, I guess, a dark green and a turquoise. And there are two comments on it as well. And it is in the page, it's on page 5 of the document. And the first, I guess I'll just take them in order, is the green items were provided to me as part of something that should be part of the policies and procedures, and in actuality are actually what is happening for the board when you're getting your agendas and you're being provided a reminder that any questions that anyone might have about complaints that are going to be heard at this monthly meeting are be provided to Director Harness no later than 2 business days before the board meeting. And so this language I couldn't find having actually been voted on or approved by the board at a meeting. That doesn't mean you all didn't do it. It just means I didn't find it. And so my question is this the intent of the board to have as part of your policies and procedures? And if so, are you okay with the location in the policies and procedures where I thought it fit? It can go anywhere that you all would like. This was just where I thought it made sense. So I guess that's the first question that I had for everyone's consideration this evening, is that. So I'll start with that so it doesn't get too confusing for any motions or anything else that the board would like to do.
Member Galloway.
Thanks, Tina. Yeah, I think that it's good to have this as part of our policies and procedures. Along the same lines though, and I was trying to find the same thing. We were working in tandem this week, or I was doing it this week. But there was also some discussion that was held about when the cases would be uploaded to SharePoint for the board to review, to give us enough time to do this. So kind of working backwards. And I couldn't find in minutes or anything what that discussion was, but memory tells me it was at least a week before the board meeting. So I don't know, Tara, I know you've been a part of a lot of the same conversations I have at the committee level and board. I don't know if you remember.
I don't actually remember us establishing it. I do, because I had a similar question when I was looking in SharePoint this last round, and I was like wondering about what that timeline was. And so I don't recall. I do recall having the discussion about the 2 days prior. I recall talking at some point about having enough time to look at things on SharePoint, but I don't recall if it was a vote type situation. And because our minutes are very sort of skeletal, it's hard to like find where those things happened.
So I guess the only thing that I would suggest is that we include, in addition to this, some language that talks about when the agency will make cases available to the board. And in my head, a week sounds like it's fair, but I'll leave that to the board.
I agree. A week is good.
I would add one other thing, and that is that it must be received by the executive director no later than 2 business days, as opposed to naming the director.
I don't know, Director Harness, is 10 days too quick of a turnaround, or is that too cumbersome for the agency? Just offering board members the ability to have a weekend in there too, an additional weekend of downtime.
Chair Cast Member Galloway. So you're wanting to ensure that all the case information is uploaded 10 days prior to a meeting for your review. 10 calendar days?
10 calendar days, yeah.
Well, I mean, I don't know. I mean, it's just the cases get done when they get done. So there will be a cutoff, and then that will mean that there's a greater likelihood that some cases will go to the chief, because essentially then you're building in a 40-day period of time before something would get evaluated by the board if it involves discipline. So I guess that 3 days isn't really going to make that much of a difference.
Yes, Member Armijo Pruitt.
Alternatively, if 10 days is onerous, I think being alerted when something new is put on closer to the actual meeting date might suffice. I mean, if I go to SharePoint and I see, oh, there are a lot of cases here, and I pull them down and I make files and I start my process, there are times when I go back like the day or 2 before a meeting and I look and I'm like, oh, there are a couple of new things in here that I didn't know were here. And so, maybe we could have, instead of 10 days, maybe it could be a week, but that if we get something that's getting close, that we're alerted to look again. I don't know. Just trying to think of a compromise.
Comments? I mean, what we're just talking about is just the cutoff date. I mean, the cases it's just cutting it off on basically the 1st of the month rather than the 5th of the month or something like that for when cases are available to be considered. I mean, any case that went up later past the deadline would just get considered at the next board agenda. Is that right? I mean, as cases flow through the process, they're going to be, they're going to come out in some sort of irregular basis, and you just say at this particular date, these are the ones that are going to be heard at the next board meeting. I mean,
I find it a little interesting that we want more information requiring more work. Now we're wanting to extend, shorten the time they have to do the work. So I would say we stick with 7 business days or 7 calendar days.
The only reason that it's an issue, Doug, is historically our agendas are much bigger. Our caseload is much bigger to review.
Yeah.
It's not 1 or 5 or 10 cases. And cases this month didn't go up until Friday. And our board meeting was on Tuesday. So that left, 3.5 days essentially to be able to review cases. And if we have a fuller agenda, that's problematic for those of us that aren't, you know, as free with our time.
Yeah. No, I know, I get that, but I mean, again, I think we're wanting more information, and I think, I just don't think you can have it both ways. I don't think you can ask for more information and then extend the time that you get, you know, that you're giving them to get that information to us. So I don't know what the balance in that is. I would suggest that we don't change it now. We see what happens with getting the more information and see what the workload is once we hear back from Director Harness about the impact on the agency to do that. And then, you know, we can always ask for the 10 days if that seems to be something that's manageable for everybody. But, you know, if you're going to set up a standard that can't be met, I'm not sure we've accomplished what we want to accomplish. That's all.
Tara, were you going to say
Valerie.
something?
Just that if we're asking for more information, it also means that we need the time to review that information, right? So, you know, 3 days or whatever. I mean, I know we all have taken on this responsibility and we all have varying home responsibilities. You know, I work at least a 50-hour week every single week. I have 2 children. I have a husband who I, you know, don't see as often as I would like for all 3 of them. And so I have to kind of be creative about when I do this work, right? And you know, our meetings and our committee meetings, and then there's the other time commitments. And so, you know, deciding that, you know, three days, 3-4 days, and I've got to review everything. Well, maybe, because quite honestly, for part of today, I took PTO from my regular job so that I could make sure I had gone over and knew what I was looking at for everything that we're talking about tonight. I have the luxury of being able to do that because I've built up a bunch of PTO, but those are the trade-offs that are happening too because of timing. And yes, it's difficult to ask for more information, but it also, I mean, we are supposed to have access to the information with which to go over this stuff, and we have to have time to look at it as well. So yeah, it's a hard ask. I get that, but I think we're all doing a hard thing in our own domains within which we are doing them. So.
And as written, we would have not been in compliance with our policies and procedures anyway with this board meeting. We wouldn't have had 2 business days to provide Director Harness with the questions. I did good to get it to him at 1 o'clock in the morning, Sunday, Monday night. You know, I think it needs to make sense. If we need to give him 2 business days to answer questions, which is fair and which was discussed with him and agreed upon, we need to be able to back it up to when we are going to have the cases to be able to do that.
Don't we?
So I think we're covering the same ground, and so I would entertain a proposal for language, and then we'll have something to work with here. So, I mean, we're still talking about upon director's review and approval, findings letter will be sent to complainants only after board members individually review complaints and findings letters and approve of the agency's finding at a properly noticed meeting. So all questions and concerns regarding complaint findings must be received by the executive director no later than 2 business days prior to the board meeting at which they're to be approved and not by the board. And so what we're asking for is how much advance notice before that 2 days time limit. Essentially, how much time is the board asking for to review these cases, so that there's just a posting deadline. This really doesn't affect anything other than the cutoff date at which they're posted. I mean,
so I would recommend language.
To be clear in this. So if you go ahead, if you have some,
I'll make a
language you wanna add.
motion.
Okay.
Yeah.
All right.
I'll make a motion that this reads as written up until the point where it says all questions, concerns regarding complaint findings. I would insert right there a sub-point 1 that says something to the effect of all investigative material will be posted for board member review no less than 10 calendar days prior to a regularly scheduled board meeting. And then sub-point 2 go on to say all questions and concerns regarding complaint findings must be received.
Chantel, if you could restate that second sentence, because you keep going in and out just a bit. I don't know if it's just on my end. Sorry about that.
Okay, starting with what, Valerie? The
Your second point, all question.
yeah, so it would be worded exactly the same. It would just be sub-point 2 or B. I guess it would be A and B.
Okay.
So that was the motion.
So do you have that well enough to read it to us, Valerie?
I have all investigations will be posted for the board meeting. But she kept going in and out. I don't know if it's on my end.
Sure. So it would say sub-point A, all investigative materials will be made available for board review no less than 10 calendar days prior to a regularly scheduled meeting or a properly noticed meeting, whatever that needs to say. And then sub-point B would continue on just as Tina has written.
Council Gooch, have you got that?
Chair Dr. Cass, Honorable Board, and Ms. Barella, I believe I have it. And Member Galloway, I don't know what's going on with your sound. Now it's very quiet. Anyway, what I have is all investigative materials will be made available for board review no less than 10 calendar days prior to a regularly scheduled meeting. I would propose that the board consider a friendly amendment of or special meeting in which the case is scheduled to be heard, just so that it's enough to provide guidance in the event that the board is going to have a special meeting to consider a case. And then B is all questions, concerns regarding complaint findings must be received by the executive director no later than 10 business days prior to the board meeting at which they are to be approved or not by the board. I can cut and paste it and share it with everyone if you'd like.
So if that captures what you're after, can we move on to the next item and then ask for approval of this as a
Do you
whole
want me to
at the
withdraw
end?
that motion?
So go ahead.
Dr. Cass, Board Member Galloway, I think that it would be helpful if you were to withdraw that motion for consideration on a whole when we get through the other portion of my questions for the board.
Done. Withdrawn.
Thank you all. And the next thing you will see in this draft is the language that the board voted on at the September 10th meeting. This is the turquoise language. It is verbatim what you all voted on, but I couldn't find where you wanted this to go in your policies and procedures. In looking at this draft, I think where I've put that language makes sense, but it could go anywhere you all would like. And as part of that, now that I've looked at the changes to the green materials, I'm not sure if they fit all together as one, or if you would prefer to have the green materials further into your policies where you actually talk about the board's review under section 6A, which is page 20. I don't really think it matters so long as you all can find what your policies provide, but I couldn't tell where it was supposed to go and I didn't want to take it upon myself to decide for you. So I'd like the board to please decide where you would like these in your policies and procedures.
If no one has any strong preference as to where to put this material, I would suggest that we leave it to Attorney Gooch to put it in where she thinks it's best placed. I think what we've had in the past, and I think we're trying to get back to that position again, is that our council has written essentially the policies and procedures with our input, but basically they're the keeper of the policies and procedures. And I think that's an appropriate place for them to be kept. So I guess I'm trying to keep the responsibility there and rely on her judgment to keep these in order. So without strong objection, I would leave it. I would turn this back over to you. Do I hear any argument to the contrary from the board? So
Not really. Tina, are you thinking though at 6 between B and C maybe, or where are you thinking when you say words? What are you meaning there?
Yeah, so for the dark green, it would be page 20. Well, it's my page 20, but in fairness to you all, I've been editing the document as we've been talking. So it's 6 where it says board review. I would say it would go between A and B. A says the board shall proposed findings and recommendations at any properly noticed regular or special meeting. And then green section would go there to provide basically the tools that the agency and the board need for that review process is what the green language is being that, the director will provide you all with this information, and in turn, you will provide him with the questions that you have so that you can conduct the next steps in your process in section 6.
any other comments?
I agree with you. I'm just thinking that it may be better suited between B and C. Because B would kind of give a precursor to what you're going to be looking at. Now here is the information and when you're going to get it. And then now that you've done that, blah, blah, blah. But it's not a super strong opinion in any case, just since you brought it up.
Chair Dr. Cass, Board Member Galloway, I appreciate the input. I think it can go anywhere. And if the board would like to make a motion on my items, those were the 2 things. And however the board would like to proceed is fine with me. I'm happy to be the keeper of the document, as Chair Dr. Cass has pointed out. I'm also happy to let the board make these types of decisions.
So I would entertain a motion to place the first item where it is. Is that correct? That's what you're suggesting. I'm color challenged, so the green one where it is, and the item, what page is it currently on? It's on page 5, I believe, right?
Chair Dr. Cass, that's correct.
And then move that to page 19 or 20 between item A and B or B and C. So,
Chair Dr. Cass, that is correct.
So pick one, A or between B and C. How's that?
Perfect.
So that's my motion, or I can ask for that motion, or I can make that motion. I'll make the motion that we move it to page 20 and that spot identified as between items B and C.
I thought I understood you say the blue would go there? The green, right? The green, yeah. Okay. The second.
Okay, don't hold, then you better make the motion.
I would make a motion then that we move section green as amended previously down to page 20 on Tina's document between items B and C.
Okay, my mistake. I'll second that. Any discussion? Seeing no discussion, I would call for a roll call vote to make the, to approve the motion to move these items as suggested. Member Armijo Pruitt,
Yes.
Member Galloway,
Yes.
Member Mitchell,
Yes.
Member Nixon,
Yes.
Member Olivas,
Yes.
and the chair votes yes. So it's back to you. We had the motion passed unanimously to move these items. So I believe, so does that take care of the two items that you had? Member, Council Gooch?
Chair Dr. Cass, Honorable Board, I think I just also need a decision on the placement of the turquoise items under the subcommittee to address where the CRC audit functions have been added. Again, the language itself was already voted upon by the board in September. It's simply, I guess, a motion to approve placement of that language as noted in the policies and procedures.
Do we have a motion to approve placement of the language as voted in policies and procedures? And we have a place for it currently, right? And you're happy with that place? So,
Chair Dr. Cass, yes.
so I would entertain a motion to place the language as, what was it, the turquoise language? The turquoise language in the place that it already is in the policies and procedures.
So moved.
Who's going to second that motion?
Second.
I'll second it. All right. Seeing no discussions, Member Galloway.
So sorry. I would actually suggest that it become item I under the same section that we were just talking about for continuity's sake.
Chair
Yes.
Dr. Cass, Honorable Chair, I'm sorry, old habits die hard. Member Galloway, we already have an I in that section. So are you proposing that it would go after that I, or are you proposing it would be labeled?
Sorry, it's again on page 20, the last one that I see is H before item number 7.
Oh, I'm sorry. So you're talking about putting the subcommittee CRC review under article.
I,
Okay, in section 6. Okay.
because ultimately the board has to approve the audit findings. CRC does the legwork, but the board approves the findings or the recommendations, I guess.
Chair Dr. Cass, Honorable Board, I am happy with that location as well, if that's what the board would like.
So would you pose that as an amendment? I think that's what we have to do, is amend my motion to.
So I would amend your motion to move the accepted language from its current proposed position to item I under the subheading of board review.
Second,
Second.
all in favor, Member Armijo Pruitt,
Yes.
Member Galloway,
Yes.
Member Mitchell,
Yes.
Member Nixon,
Yes.
Member Olivas.
Yes.
Chair votes yes, passed unanimously to move the language as section I into that appropriate section. So where are we?
Chair Dr. Cass, from my perspective, that closes out this agenda item. Those were the only 2 issues I needed the board's guidance on.
And then if we move on to item F, CPOA policies and procedures modification, this will also follow. There is also modification to our policies and procedures. So I would turn this over to Member Olivas, and he can introduce the language that I believe he was planning to introduce to get the director evaluation in the policies and procedures. And that would be part, I mean, this goes back to you as well. I mean, this all is going to come back into your lap. So Member Olivas.
Yes, so let me pull these up here real quickly. Trying to remember, Councilor Gooch, you suggested this would now be Article 3, Section 9, I believe, but that may change too. So I think we would probably defer to you as far as what section this is. But these are proposed additions to the policies and procedures in relation to the executive director evaluation. I'll go ahead and read through them real quickly. There's fairly short. So all of these are additions. These are not changes to anything existing. And I believe this is under the section that deals with the executive director position. Number 1, the annual review period for the executive director shall run from January 1st of a given year until December 31st of year end. Number 2, the goals for a new evaluation period shall be approved by the board no later than September of the year prior to the evaluation period. Goals shall be drafted with input from stakeholders, including CPOA staff, board members, and the executive director. Number 3, evaluation materials shall be prepared and approved in final form by the board no later than November of the year preceding the evaluation period. Number 4, a mid-year informal evaluation update meeting shall occur between the executive director and the personnel subcommittee during the month of June in the year of the evaluation period. This meeting shall allow the executive director to communicate any concerns or difficulties in achieving goals to the board. Number 5, the board or a representative of the board shall present and discuss the draft completed evaluation matrix and evaluation summary with the executive director prior to final board approval. And number 6, the final evaluation summary shall be approved by the board no later than April of the year following the evaluation period. So I would like to make a motion to adopt the proposed changes, proposed additions to the policies and procedures in relation to the executive director evaluation, with the stipulation to defer to our legal counsel on exact numbering and basically exact numbering and minor edits if needed.
Second.
Any discussion? So hearing no Member Armijo Pruitt.
Thank you, Chair Cass. So something that just occurred to me while you were reading that, and it probably should have occurred to me to ask this at the beginning of this whole discussion about the evaluation is, are we going to consider the CPC's input as stakeholders in this process?
Yeah, I think that's a fair consideration. At the time that we were drafting this, that was unclear, right? Whether or not that would happen or how that would occur. I guess I would try to answer your question by saying for 2020, I don't think that it would really be appropriate to do that either way, since the period we're defining, if the ordinance goes into effect tomorrow, I believe, right? That only leaves roughly 3 months of this year to evaluate. But I think that's a fair point for 2021, that's an important consideration. And I think we can take that back to the subcommittee and try to come to a way to include that, because I think it's important. It sounds like you do too.
Chewing.
Any other comments?
No chewing. No chewing.
I'm hearing noises. With seeing no other, I'm Director Harness. Were you? Oh, okay. All right. So hearing no other discussion, I would call for a roll call vote to adopt the language as presented by Member Olivas as he read, and leave it to our council to get this into the right place in the policies and procedures. So all in favor by roll call. Member Armijo Pruitt.
Yes.
Member Galloway.
Yes.
Member Mitchell.
Yes.
Member Nixon.
Yes.
Member Olivas.
Yes.
And the chair votes yes, so the motion passed unanimously. The last modification to the policies and procedures, or proposed modification, is the order of business. And the current order of business is found somewhere back in the policies and procedures. And if you look at it, it's far out of date from what we've been doing, even recently. And the change that we adopted tonight is essentially was done with some consensus that came out of our facilitated meeting, that it was suggested that we might move up the hearing, the case review to earlier on the agenda. So what I would recommend is the way we modify the order of business as found in the policies and procedures is to adopt the order that was used tonight as the baseline order. And I might also add that within the order of business and within our policies and procedures, there's a statement that's essentially an out for any process that we do, or any agenda that we do adopt. And it says, the chairperson shall have the discretion to proceed out of order to any order of business or return to any prior order of business. So we have the ability to be flexible already. We might just want to have the policies and procedures reflect the order that's somewhat closer to what we're doing, what we're trying to achieve, which is to get cases heard earlier in the meeting. So with that, the motion I would make is to adopt the agenda order that we use tonight as the baseline order for future agendas. So is there a second to that?
Second.
All right, now I believe Council Gooch, you may have some input here. Were you raising your hand?
Chair Dr. Cass, no, I was just typing a note about updating this based on your vote. I'm trying to do it in real time to help all of us keep.
Okay, so is there any discussion then about the motion to adopt this order of business as the order of business, the baseline order of business, which obviously can be modified? Hearing no discussion, I'll call for a roll call vote to adopt that motion. Member Armijo Pruitt.
Yes.
Member Galloway.
Yes.
Member Mitchell.
Yes.
Member Nixon.
Yes.
Member Olivas.
Yes.
And the chair votes yes. So motion carried unanimously to change the order of business to reflect tonight's agenda. So that ends our discussion and possible action items for the night. There's no, I believe we have it on the agenda that, as item 12 is the meeting with council. We have no meeting scheduled. This is a placeholder for future agendas. And so that brings us up to item 13, other business. And I believe we deferred the response to the officer to the use of the canine, use of force with canine to other business. So I would like to bring that back to the floor. And I would make a suggestion that the decision to not hear the officer or the canine case was essentially the board chair's decision to control the agenda or to create the agenda. And so I think the solution to this would be for the board chair to respond to this, to Mr. Larson's request for explanation as to why this wasn't done. And I will assume the responsibility to do that. So this is what I would suggest we do. So
Makes sense. That closes the loop. I think it's appropriate to respond directly to him since he took the time to send the email. And I think it should just be kind of a synopsis of what happened and what we did to correct it. Short and simple.
Thank you. That works for me.
Agreed.
any other comment, discussion? So I will write an email responding, as the chair in charge of the agenda. So that's, I mean, that'll be the, that's the position from which I'm, making the response. So I think the IPRA request was responded to appropriately. I think the rest of this is a board decision or a chair decision. So I don't know if that needs a motion. I'm just stating, what I think I can do within my power as chair. So if that's agreeable, I'm just looking for some affirmation. I think I have it, so I'm happy to move on. Is there any other comment about this? Okay, I would entertain a motion for adjournment.
Dr. Cass, I wanted to raise one item of special business. It should be a quick one. We had extended an invitation to the previous chief. Thanks here to Member Galloway for refreshing my memory on this. We had extended an invitation to the previous chief to meet with us and talk to us about staffing issues at the department. And I believe that was back in February or March. And then we had a series of meetings that were canceled due to the pandemic. And then of course we've moved online since. So I think that kind of got lost in the shuffle, but I'm hoping that given the board already approved action on that we can resurrect that and reassert our interest to the new interim chief in having him join us for meeting and expecting to speak on that topic.
I'm perfectly willing to put that in the agenda. I think it's worth, if it works better if there's consensus from the board that that's what they would like to hear, and I'll take this as that kind of consensus.
It was actually a motion voted on and approved by the board in February or March, I forget which, for the executive director to extend that invitation for the following month. I think it was March because April we didn't have a meeting because of COVID. So
I think it was March we didn't have a meeting. In April
then February and March.
Right.
Yeah.
Right.
But it was right at that time, and I think that probably got lost in the shuffle.
Well, it's pretty easy to resurrect that, so we can do that. Any other business? I would entertain another motion. Yes, Member Armijo Pruitt.
Thank you, Dr. Cass. So I just wanted to, I wanted to talk about something really quickly that is sort of something that has been on my mind a bit about being on the board and how we address certain kinds of cases that involve women. And there are two cases in particular in the past that have really kind of stuck in my craw. And I was reading something from a group that works with women who are sex workers. And they were giving this recollection about, I'll just read it. A few weeks ago, a woman who we serve was raped by a man on the street who wanted to do a date. She went to a friend who, after seeing the extent of her injuries, convinced her to call 911 a few hours later. When the responding patrol officer was taking her statement, he asked, "What took you so long to report this?" She instantly felt like just another low-life druggie who doesn't matter, in quotes. As she told us this story, she said she didn't know why such a simple question had such an impact. But that question is anything but simple. It actually does two important things. One, it makes a judgment, a moral judgment, and two, it signals disbelief. Another way to phrase the question is, you should have reported this sooner. And even though the officer didn't use the word should have, linguistically, the question has the weight of a should have sentence. And why is that important? Because the word should is a moral indicator word. Should equals judgment. Signals disbelief. In our society, police officers, even those who respond to regular 911 calls, are determiners of truth. We all know this because we collectively have bestowed that power on them. When a determiner of truth asks, "What took you so long to report this?" we know they are questioning the truthfulness of what we've said. The officer is basically saying, in other words, if it's a real crime, you would have reported it sooner. So by asking one simple question, the police officer told the rape victim that she is, one, morally lacking, and two, not telling the truth. Did the officer mean to do all of that with the question? Probably not. but his intent doesn't matter. The responsibility of the interaction lies solely on his shoulders because it's his job. And police officers should, the judgment word is intentional, realize that rape cases are different. With rape victims, the first on the scene officer must not be the quote unquote determiner of truth, but instead become the acceptor of the victim's truth. There will be time for follow-up questions with the victim later and initial interviews while on the scene. The victim needs to be heard and believed, that's all. Now, you can pick that apart however you want. But what resonated with me when I read that was when we sometimes consider some of these cases like we talked about in the last meeting, I think, where a complainant says that she thought she was drugged and assaulted and felt like she had conveyed that in her compromised state to a police officer and nothing was done. That the way the letter is written in response to her case was very dismissive. And that happens a lot when these are cases, in my opinion, when these are cases of women who are making complaints, where there's a level of judgment in the tone of the letters and where the conversation feels very dismissive about some of these situations when we talk about them. And I'm just asking that you guys sort of carry that thought with you and think on it and see if that, if you reflect on that and see if you can find any place where that resonates, because for me, it resonates very strongly in what we're doing and what we should be doing. So that's my piece.
Could I ask you to send that out to the board, the letter that you have?
Sure.
I mean, I think that gives us a better chance to reflect on what you're saying and give it some consideration. So I appreciate your bringing it up, but I would like to have more. Would like to have it in in print in front of me to
sure.
see it, and the source as well.
Yeah.
Mm-hmm.
So thank you.
But I'd like to have a follow-up discussion with it too, even if it's an agenda item or whatever we need to do. But I thank you for bringing that up, because we, as the board, I think we can do something about that or take an action. But I'd like to hear the feedback and make sure we have an action item to get together and talk about it.
I don't believe there's anything that prevents you and Member Amia Pruitt from having a discussion and presenting something jointly to the board if you see that as something you want to do. But we're not violating any quorum rules, and I think there's having two board members agree on something like this or work on it, I think would gives it some weight as well. So I'm encouraging you to get together. So Member Galloway.
That actually is an interesting thing, Tara, that you bring that up, because it's kind of just like, how do we, it's that dialogue about how do we want our police department to look like? What do we want that to look like? It's not necessarily an SOP violation. It's just tone conveyed by the police department. And I've been wrestling with something. I had a brief conversation with Director Harness about it, and I've kind of still been sitting on it because I don't really have a complaint to lodge, but I have a concern, and I don't know where that falls within our purview. And Tina, maybe you can help, or maybe we can kind of decide as a board what that looks like. But when we're out and about and we see something that just makes us stop, and this is now going on about 7 weeks that I've been sitting on this, and I think about it daily, but I don't have an SOP to point to say that was violated. I don't know that anything was violated. So to file a complaint with the agency may be a misuse of their already limited time. But what do we do with stuff like that? What do we as an oversight board, or we as community members do? How do we foster those conversations, I guess? Does anybody have any thoughts about that?
Well, I think this whole conversation is a really important point, and I think that you're raising kind of what speaks to our mission about maybe there's not an SOP violation, but maybe there's a conversation that needs to be had at a deeper level about the SOP itself, or maybe there is no SOP, there is no policy on this, and we're kind of speaking in broad terms here because I don't know the details of this, but I guess at this level, I would say, you know, maybe it's something that needs to go to that policy level analysis. What are we doing or not doing to address something in a systemic way? And we know that that's certainly happens in other areas, and this certainly could be the case.
Isn't it a training issue within APD on how they train their officers on these type of interactions with citizens? I mean, it seems to me it'd be pretty a basic training around sensitivity and, you know, especially in that situation, to be very careful about how you frame things. I would see it more as a training issue than an SOP issue.
But do we have a mechanism as an agency and a board for stuff like that? We have a very clear mechanism for complaints and findings and whatnot. But when it's kind of nebulous like that, do we have something? Tina, I see you like.
Chair Dr. Cass, Member Galloway, I think that Director Harness could probably speak to this as well, but the ordinance does provide policy recommendations that the board is supposed to engage in long-term plannings, and that it can identify problems, trends, can evaluate existing policies, it can utilize data to then make recommendations. If it isn't a policy or it is falling through the cracks and there's a policy needed, the ordinance gives the process, if you will, very high level for this board to provide that analysis. And then also how to provide those policy recommendations that originate strictly from the CPOA as opposed to APD. But again, I would defer to Director Harness about how in the past the board has utilized those powers. And it's kind of unclear from the way in which the question's being raised, if that even answers the question, but I feel like it might.
It's more of a triggering mechanism. Like we would review SOP violations and develop trends from SOP violations or numbers of complaints on an SOP. But if you don't actually have that, if it's just you know, I saw this, I'm not sure that everything was okay. And what does that look like as far as, do you just sit on that? Or how do we say to the agency, you know, would you take a look at this CAD and this lapel video and see if there's anything that was concerning? Because that's kind of a fishing expedition, right? And that's not anything we want to get into long-term, I wouldn't think.
But I think we can, where the board can be active in this is to identify issues that start with policy, but they end up as a training issue. And I think Member Mitchell's comments, is right on. I think that, you know, if you watch the YouTube videos of police interacting with the public in a variety of ways, there's some cultural, component, a very strong cultural component, which is trained in or trained out of police in order to act more appropriately with members of the public. And whether it's a rape victim or whether it's somebody who's filming, walking down the street carrying an AR-15 or walking down the street carrying a camera, there's always a police interaction which points out the distinction or the differences between the training that some police officers get and others don't. So I think it is within our our mission to deal with that. I think it just needs to be identified as to what particular training we're interested in looking at. And this is one of the things that came out of this request from the training committee to have input into their curriculum. Their meeting, the training committee is established by an SOP, and it says it will take information from the public and modify their training according to suggestions from other departments within APD, as well as they're soliciting some public input from stakeholders. So I think we're on the policy committee. We've decided that we want to deal with that. I think this is the place to start the process. I think where it goes from here depends on what we identify as important training. So
So then is the mechanism to filter that kind of stuff or like this document that Tara was reading from, and any suggestions that may come from that or opportunities that may present itself from things like that? Is that a filtered through the policy and procedure for vetting and see if it warrants further action?
Well,
Is that kind of what we're thinking?
I think it could be, but one of the things we want to do, and this is one of the problems we have probably on the planet when it comes to issues with women, is that it gets lost in translation, or it gets rolled up into this bigger issue, when in actuality we need to stay focused on the interaction of police officers with women. And that's to member Armijo Pruitt's point. I mean, especially coming from a toxically masculine kind of industry, for lack of a better term, I think I'm okay with it as long as we can keep it where we're focusing on women's interactions, or should I say female interactions versus police officers, whether they're male or female, and what that means, and you know, identify that. I'd like to see that kind of separated out so that it's not lost in the translation of the guy that's walking down the street with an AR-15 or something like that. We're talking about a specific issue that needs to be addressed across the board, specifically. So.
So, is there any other business for this evening? So I would like to remind you that there is a special meeting scheduled for October 26th. That'll be our next meeting of the board. And if I hear no other business, I would entertain a motion to adjourn.
So moved.
Second.
Member Armijo Pruitt, all in favor?
Yes.
Member Galloway,
Yes.
Member Mitchell,
Yes.
Member Nixon,
Yes.
Member Olivas,
Yes.
and the chair votes to adjourn. The meeting is adjourned. Next meeting, October 26th, the subsequent meetings in November 12th, I think.
Thanks, folks. Good night.
Good night.
Night,
Thank
everybody.
you.
Good night. Thank you.
Good night, everyone.